In the second matter, I am not pressing for that application, my lord, permitted to withdraw. Same matter, fresh.
I don't have to say anything, my lord.
Say no. We only will say that. Why you are not pressing that application?
No, I filed, my lord, fresh writ petition.
ನಿಮ್ದು
ಅಲ್ಲಿ ಬೇರೆ ಇದೆ ಇನ್ನೊಂದು.
ಬೇರೆ
Which you may not be aware of. Yes.
is better than not. ಇಲ್ಲ
ಆಯ್ತು. Next sitting day.
Next sitting.
Seal number 2, I am not pressing that application, but permitted to withdraw. Because fresh petition is filed.
Call list.
ಏನದು?
Counsel for the petitioner files a memo that he was not. This. ಇಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಮಾತ್ರ
This is a disposal of matter. Only application I am not pressing because I filed a fresh petition.
Land users ಮತ್ತೆ revenue side ಹೋದಲ್ಲ. But allotment ಆಗ್ಬೇಕಲ್ಲ. Well, yeah, lordship. With regard to that, my lord, only thing is, my lord, at least insofar as land losers are concerned, my lord. But this report. ಏನ್ report ಅದು?
Regularize ಮಾಡಿದ್ದಾರೆ ರಿಪೋರ್ಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ we need what present status details.
Full details.
We'll do that.
File everything.
Please, we'll file the status report.
Yes.
Status report, will pass a detailed order and consider permitting.
Please, one other aspect, my lord, your lordship, there's a report dated 7/3/2024 and 25th. And you kindly see the order, cause list, my lord. That report, if this,
Of
the committee report earlier, my lord, that will help us to decide few of them.
ಇಲ್ಲಿ ಬಂದಿದ್ಯಾ? ಇದು ಮೈಕ್ ಯಾಕೆ ಆನ್ ಆಗ್ತಾ ಇದೆ? ಕರಿ.
ನಿಮ್ಗೆ ಏನಿಸ್ತದೆ? Because most of the cases, they're not aware as to what has happened to the decision on the report. This report contains those decisions. Please, Malone. That is dated 7th March 24 and 25th April 24. That's in the order cause list itself. If a copy is given, so whoever are connected with the petitioners, we can assist to dispose of those matters in terms of the committee's report. Because quite a few petitions are saying that recommendations have gone, matters not, reports are there, Supreme Court are not decided. So your lordship will have to decide instead of the Supreme.
That will do and the applications part of it, you file the status report, next sitting we will.
Please, Manoj, in detail, comprehensive will file, and till now, and the way we move forward also, I'll file, Manoj. No, if your lordship permit, the way we are moving forward, let that also and be on record so that everything, how we are going to,
Then come.
easy for your lordship, please. Okay. Please, madam. 7/3/24 and 25/4/24. Okay. No, no, no. Num copy is there. But where copy next?
25/4/24.
More than 7/3/20. First is 7/3/24.
It's here, both are here.
Both.
Pass orders.
Please, ma'am, so that it will be helpful. Your Lordship may kindly see serial number 1 in that, my lords. Please, Your Lordship may kindly.
By the end of the day.
Because the reason is this, there's 105 applications has been decided by the committee. So number of cases based on that decision, these cases will get disposed of. So we'll give those number of 105 cases to, we don't have unless that list we see. So we can,
Sorry, not come.
so that we can give the same case number so that. Yeah. Correct, okay, note bit, yeah, very good, yes. We'll just make a note of it and then we'll give it by the end of the day. Of your Lordship's permit, during the lunch hour, we'll take it, make a note of it, please.
Three. Or B.
Let's, this review petition is actually already disposed. Kindly permit me minutes to just pass on the orders minutes that have been passed.
Review is disposed or what?
Review is disposed. Minutes, what had happened was, learned single judge minutes had dismissed my writ petition. I had filed a writ appeal. Minutes, your Lordship's minutes permitted me to withdraw the writ appeal and approach the Honorable Supreme Court. Minutes, I challenged the order of withdrawal and not the order of the learned single judge, and therefore the SLP minutes was dismissed. I then come and file the present review petition. This review petition was dismissed again. In view of the dismissal of the SLP, since I challenged that. Therefore, I challenged the single judge's order as well as the order in review before minutes the Honorable Supreme Court. The Honorable Supreme Court set aside all the orders and minutes remanded it back in view minutes of the bench, this honorable bench being constitutional. So therefore, minutes, the
We'll have to decide the main matter.
writ petition has to be decided.
Fresh.
We'll decide it afresh.
Please. The registry is supposed to list the writ petition because this is
Correct.
already.
ಇದು dispose of ಆಗಿದೆ ಮತ್ತೆ dispose of matter list ಆಗ್ತದೆ. Three.
1250. History to put up the papers in writ petition.
12503 of 2021.
12503 of
WP 12503 of 2021.
Petition, you handle people. That is why. Even though petition, effect is petition itself is restored by the apex court. Because all orders are set aside.
All orders set aside.
We will post the writ petition.
Please, that's what. Please.
So the order copy there, no?
This we do.
I've produced it by way of memo minutes, all the orders.
Idea?
Please, ma'am.
Writ appeal actually,
The writ petition post ಆಗಬೇಕು.
writ petition post.
ಅದರಲ್ಲಿ ಮೆನ್ಷನ್ ಆಗಿರುತ್ತೆ.
Okay.
Please.
Petitioner.
On the previous occasion, my lord said directed the government to seize the documents of the Gram Panchayat.
ನೋಡಿದ್ರಾ?
ಎಲ್ಲಿದೆ ಮೆಮೊ? ಮೆಮೊ.
Separate ಇಟ್ಕೊಳ್ಳಿ.
ಫೈಲ್ ಮಾಡಿದೆ.
ಸೀಜ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ ಅದಿದು.
For purpose of.
Back side.
The dispute was, my lord, whether it was.
The Gram Panchayat did the exercise. Resolution book ಎಲ್ಲ ತೊಗೊಂಡ್ರೆ ಈಗ ಎಷ್ಟಿದೆ ಅದು? ತುಂಬಾ ಇದೆಯಾ? ಸೆಕ್ಯೂರ್ ಮಾಡ್ತೀವಿ.
In terms of the order dated 10/1/2025 had this court on 10/1/2025 had passed the following. Pursuant to the directions so issued by us, the learned AGA has placed on record the factum of seizure of the records in the said Gram Panchayat concerning the present petitioner and the resolutions passed thereon. The file hakidira memo. Yes, sir. And has filed a memo to that effect. Memo is taken on. The records that are now in custody of the state after the order passed by us supra be placed before us on the next date of hearing.
Week after next. Not the remote has been done on this.
Is it interim order?
The representation.
Petitions. Mandamus. Sought for mandamus for regularization.
Consider representation. Annexure A and B.
Annexure A and B.
Notice. Notice to be issued. It's coming up for the first time. Notice may be issued, and there.
Two and three.
For one.
And
Petitioner is before this court seeking the following prayer.
the petitioner from this court that several representations had been submitted to the committees so constituted, one of which is appended to the petition dated 11/2/2021. Because it is averred in the petition that the committee had not passed any orders thereon. Therefore, the petitioners have again submitted a representation for regularization of the dwelling house. The representation not having met its consideration is what has driven the petitioners to this court, the subject petitioners. The subject. The learned counsel appearing to the respondent video submits that if reasonable time is granted, he would consider the representation and pass necessary orders in accordance with law. In the light of the said submission, we deem it appropriate to dispose the petition, directing the respondent BDA to consider the representation submitted on 14/12/2023 for the purpose of regularization of dwelling house and pass necessary orders in accordance with law. Any document, any further document that is necessary for the purpose of such consideration can be solicited from the hands of the petitioner. The decision taken upon the representation shall be communicated to the petitioner. Till a decision is taken, representation, status quo, way, the construction in the property be maintained by the parties. Ordered.
My lords, in annexure A, the survey number is mentioned as 13. It is survey number 14, my.
Survey number?
14.
Subject
Survey number
property.
14 of.
Subject property.
Covered.
Okay. The petitioner in this case, my lords, I seek for a short accommodation.
Application of new act.
There's an interim order operating on it.
That is.
All matters.
Same.
Huh?
I appear for the petitioner.
ಸ್ಯಾಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನೋಡಿ ಹಂಗೆ ಸ್ಯಾಪ್ ಅಂತೀನಿ ಮಾತಾಡ್ತೀನಿ ಸ್ಯಾಪ್ ಅವ್ರದ್ದು ಎಷ್ಟು ಟೋಟಲ್
I appear for the petitioner in serial number 7, my lords. Lords, a copy of objection was served on me 3 days back, my lords. I'll have to seek instructions. Pray for a shop accommodation.
Direction to
See the second prayer.
to allot alternative land. That's the.
And as I said, the other day, government advocate said that it would be allotted.
Yes, my lord, if they get the instruction, my lord, to that effect, their grievance is also that, my lord.
Already made a note that submission is made.
Yes, yes, ma'am. My lords may have it on 7th, my lord, will close it on that day. Because the government, my lord, has to take a call on that, but my instructions are that, my lord, government has decided to allot them certain land. But once I get a proper instruction, my lord, 7th, my lord.
You have to make the statement.
Yes.
The government has to.
The learned counsel appearing for the petitioner seeks 2 weeks' time on the score that the statement of objections are served on the petitioner 3 days ago. The learned, on the earlier occasion, it was the submission of the respondent that the second prayer B, would be considered at the hands of the respondent BDA. Therefore, the learned counsel submits that if 2 weeks' time is granted, the prayer.
Not BDA, but the government.
By the government, by the government, sorry, by the government. If 2 weeks' time is granted, the prayer would be, would meet its consideration and the consideration of which would be placed before this court.
ಅದೇನಾಯ್ತು ಅಂತ ಹೇಳ್ಬೇಕು. Today, that's the reason thrice it is being adjourned.
Please look into the order. See what is list on.
Oblige, my lord.
ಏನಿಲ್ಲ ತಾನೇ ಈಗ ಸ್ಟ್ರಕ್ಚರ್ ಏನಿದೆ ಏನಿದೆ ಅಂತ ನಮ್ಮ ಹೊಡೆದಿದ್ದಾರೆ ಏನು ಬಿಲ್ಡಿಂಗ್ ಇದೆ But it's coming on board.
Not very 1 feet coming on the road. But
ಏನು?
2022 notification left out in PN and FN minutes.
There's a small structure, my lord, which has come up after the date of notification. The larger extent of land is 12 guntas. Now the structure which has been constructed after the date of notification, small extent of which is coming on road, but rest all is vacant. So on 12 guntas of land, my lord, at best the dwelling house is around 400 square feet.
No, it's not. I'll just pass it on.
What's the dimension?
Well, it's, there are two houses, there are two millets structures. One millet is about 1,575. Another is a sheet house millets, which is about 500 square feet. Please.
Saw that last time. Nah?
It's, my friend may not be right in saying that it's come up after the notification. Come up in 2019 itself. I'm producing
ಅಲ್ಲಿ
the,
ಸ್ಟ್ರಕ್ಚರ್ ಅಂದ್ರೆ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ನಾವು ಕನ್ಸ್ಟ್ರೂ ಮಾಡಿದ್ದು ಪರ್ಮನೆಂಟ್ ಸ್ಟ್ರಕ್ಚರ್ ಅಂತ. ನಾಟ್ ಲೈಕ್ ದಿಸ್ ಅಂಡ್
ನೀವು permanent structure ಅಂತ ಹೊರಗಡೆ simple ತರ.
I have produced the Google Map images also. I'll produce it by way of memo. As of instructions, my lord, there is no structure.
I've produced the Google Map image itself. May kindly take page 2 of my memo. Bullets at the bottom. Kindly see at the bottom, bullets imagery date 28/12/2019. It's the notification 2022.
ಸ್ಟ್ರಕ್ಚರ್ ನೇಚರ್ ಆಫ್
Kindly see the structure, my lord. They have kept,
There are structures.
they constructed only towards the edge, just so that, to show that there is a structure, but everything else is vacant.
No,
ರೆಸ್ಟ್ ಆಫ್ ದಿ ಏರಿಯಾ ಇಸ್ ವ್ಯಾಕೆಂಟ್.
certainly, Milord. I'm not
But
asking.
if it comes in the way.
And the structure on the right side is sheet structure.
You
Structure.
structured your case well, but structures.
Perhaps arguments also.
There are structure, I mean, they're
Structure.
residing there.
Structure in a municipal law is construed by Justice Tillari. If it is a temporary structure, it is no structure. Unless the law otherwise indicates.
Please.
Is that, is that temporary?
Milord, your lordship, it's not a temporary structure.
Google does not differentiate between temporary and permanent,
ಅದ್ರಲ್ಲಿ
Certainly, Milord.
but we differentiate.
No doubt. It's, my instructions are that this is a permanent structure. I
ನೋಡ್ಕೊಂಡ್ ಹೇಳಿ.
let them, Milord, inspect, there is no doubt about it. They can also tell, Milord, what is the extent, if any, and Milord, the extent that would possibly go for the road.
ಎಲ್ಲೆಲ್ಲಿ ಉಳಿಸ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಉಳಿಸ್ಬೇಕು.
Yes.
Learned Counsel Rowan Hushman files a memo appending images of Google Earth to demonstrate that as on the date of the 2022 notification, there were structures in the property. The structures, according to him, what dimension?
Well, it's, about 1,575 square feet.
Together.
One.
There.
ಒಂದು ಎರಡಿದೆ ಅಲ್ಲೊಂದು ಇಲ್ಲೊಂದು and another one is about 500 square feet.
2,000 square feet.
ಎಲ್ಲ ಸೇರ್ಕೊಂಡು.
Has structures of about 2,000 square feet in the subject property. According to him, the Google Earth images has a date stamp of 28/12/2019. Therefore, the inference that he seeks to draw is that it is, the structures were existing prior to the notification of the year 2022. The learned counsel, Shivaprasad Shantangowda, has also filed the
Oh, we have not-
images.
They're not filed.
We have not filed.
Submits.
We have received it only.
That he would also file the Google Earth images. Google Earth images. In serious dispute to what the petitioner has produced. Therefore, the mediation cause an inspection of the property of the petitioner and file a report on the next date with regard to the existence of structure, its
Nature.
dimension,
Nature also.
existence, nature, and dimension of the property that is said to be, the structure that is said to be in the property. List on 7.
But they may also indicate the extent that falls for the road, my lords.
Everything
entire.
will file.
That's the only.
Date may be fixed for spot inspection so that they are also present.
In the light of both the parties being represented, we direct the VDA to conduct the spot inspection on,
29th, 30th,
on 20.
29th,
November,
the 29th or 30th, either of the two.
30th,
30th.
on January the 30th, 2025 at 11 a.m. It is the petitioner, the VDA need not notify the petitioner separately. Separately, petitioner shall be present at the time that is indicated. List the matter on 7.
Please. There's an interim order.
Matter has been disposed on 13/12, my lord. There are some typographical mistake in the order. In para number, para number 1 ನಲ್ಲಿ petitioners ಅಂತ ಇದೆ. He is the only one petition. And second
This for dispose the subject petition. The order dated 13. An application is preferred seeking correction of the judgment owing to certain typographical errors. Then petition ಅಷ್ಟೇನಾ?
ಮೂರ್ ಇದೆ.
ಏನೇನು?
Second one, advocate name change ಆಗಿದೆ. In second para, my name has not been reflected. Some other name has been. And in the third para, my lord, it's mentioned as joint property. It's a, he's a single owner, my lord. It's not a joint property.
Yeah.
Published.
Towards the end.
7. List on 7.
25 is already.
11.4 I am appearing.
Small extent is regularized. There is larger extent of land which is vacant. They are seeking dropping of the entire extent of land on the ground that
All around this. All around the plot flood, it is regularized. In fact, in 11.4, if your lordship take the photograph,
11.4 ತೆಗೆದು.
okay, sir. 11 point. Page 121.
11.4 ಅದಲ್ಲ. ಅಲ್ಲೇ ಇಟ್ಟಿದ್ದು.
ಇದು ಸುತ್ತ all the buildings are. At page 121 in serial number 11 point. Page 121 below. all buildings around Malad have been regularized. Only the central area which we need for the playground is not regularized.
What is the area?
Now, Malad, this total area is 2 acres 17 gutta.
So the area that you are seeking regularization.
Out of that, Malad, 3,000, out of 2 acres 17 gutta, 3,500 square feet is regularized. Remaining comes to about 16, it comes to about 1.5 acres of land, Malad. It is meant for school. It will be used for the playground.
Now, what is regularized is a school?
It is regularized. What is regularized is a building which is meant for a school. School is not commerce. Yes. Meant for a school because there was an injunction order. We could not complete the building. Plan is given in 2012 itself. We took sanction plan and layout plan is obtained for the purpose of school. And it is only because it is for the school, they have regularized a portion of it.
With respect to school, my lord, the Supreme Court has clearly held the school should be functioning, even to drop those lands. Similar circumstance, my lord, on our writ petition
And
came to be dismissed.
Adjacent
And my
building,
lord, in Supreme Court, my lord, that also came to be dismissed. The order passed by this honorable court.
adjacent building where there is no sanction plan is also regularized for the school. All buildings around this is regularized.
Yeah, structures regularized.
Structure is regularized, but now, my lord, the what is required on the last occasion, your lordship asked me a question. Does the law require that playground is required or not? Now in
Judgment on ಕೊಟ್ಟರಲ್ಲ.
ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ in a case to regularize it partially for the school and exclude other portion of the property, which is meant only for the purpose of playground, my lord. School itself cannot.
But there is no school.
No, school layout
It
was,
is meant for school.
no, this regularized area is regularized because it is a school
School.
building only. And my lord, this, they cannot develop this property at all.
The regularized
Kindly
area
see.
is 3,000 square feet. Now they are seeking dropping of 2 acres of 2 acres 5 guntas.
No, school, the extent of playground ಎಷ್ಟಿರ್ಬೇಕು ಅಂತಿದೆ. What is the norm? That's what.
Let them say this entire action will be reserved only for playground. Now tomorrow morning they'll construct
ಇದರಲ್ಲಿ
structures there.
This area cannot be used because exactly it comes in the middle. ಎಷ್ಟೇ rule?
No, we are asking you, if assuming that we agree with your first submission, the fallout of that would be that we have to give some relief in respect of area required for playground. That is normative. You can't have a school of 10 students and 1 acre of playground. So what is the requirement of
Rule
the
says,
area?
my lord, rule, every educational institution shall provide sufficient area for playground.
Ah.
Enough for all the students
Correct,
in the institution to assemble and to play and watch at least 2 outdoor games at one time.
correct. Although definitely not 2 acres.
In this case, my lord, this is a.
ನಮ್ಮ
this
ಔಟ್ಡೋರ್
they say
ಗೇಮ್ಸ್
is a-
ಅಂದ್ರೆ ನಮ್ ನ್ಯಾಷನಲ್ ಗೇಮ್ ಇರ್ತಾವಲ್ಲ ಖೋ ಕಬಡ್ಡಿ ಇಂಥವ್ ಆಡ್ಲಿಕ್ಕೆ ಅದು. Not
ಅಲ್ಲ,
for
ಇದರಲ್ಲಿ
cricket.
this in this particular case, in fact, this also is not part of the scheme. Kindly see, they themselves have given an endorsement saying that this land is not part of the scheme. Kindly see
When was that endorsement?
page 33 dated 2012.
ಎಲ್ಲ ಹೋಯ್ತು Supreme Court.
ಅಲ್ಲ, scheme ಅಲ್ಲಿ ಇದ್ರೆ then left out lands would arise. Left out lands, block, it should be initially included in the scheme. Later it should have been left out, but it is not included at all. Page 33.
Not notified at all. Kindly come to page 33.
33.
To Prasad.
Endorsement dated 29/8/2012.
And on that date, it was not. But subsequently, all that has come. That's it. But more than, more than 12 years ago.
ಅಲ್ಲ, correct. ಆಮೇಲೆ
Thereafter, these things have
no.
come.
After that, there was a notification and all these proceedings have taken place. But in so far as the acquisition of land is concerned, It should have been first included in the scheme, then acquisition would follow. Then at any stage, whether this land was included in the scheme, my lord, when they say it is not included, then is it included later? That they have to show is one aspect. The other aspect is, my lord, if your lordship look at the physical situation of this property, all around all properties are regularized. Now, the entire even access is will not get even access to the property.
How this 2022 notification, Shiva Prasad,
Please.
that ethics code directed you to issue notification or you issued notification?
On your
On your.
Pursuant to
Permitter of the apex code.
Left out land.
pursuant to orders of the Supreme Court, my lord, took the entire layout map before itself and saw that there were vacant, certain portions of land which were not acquired in the 2008 notification. Thereafter, there was a direction to acquire the left out lands. That is why the notification is also.
ಇದು ಲೆಫ್ಟ್ ಔಟ್ ಆಗಲ್ಲ ಅಂತ
Left out.
ಅವ್ರ ಕಂಟೆನ್ಷನ್
Because scheme
Pers-
include ಆಗಿಲ್ಲ.
ಇನ್ಕ್ಲೂಡ್ ಇಲ್ಲ ಅಂತ.
Left out lands, my lord, but for all practical purposes, it said that for connectivity purpose also and taking these, the lands which were not part of 2008 notification, those were meant to be left out land. After the prelim notification came to be issued, we submitted that prelim notification to the Supreme Court. Supreme Court then directed to issue final notification after taking note of those survey numbers,
In fact,
which were left out.
order
keeping
The notification was placed before the apex code.
Then there was a direction deadline fixed,
Notification.
Yes.
Final notification was again
was
placed.
was also
before-
placed. Then there was a direction to take possession.
No, that is not correct, my lord. What happened was, my lord, initially, some of the lands came to be dropped after issue of preliminary notification is one aspect. The other aspect is that they said that even if it is included in the scheme, that land also has been left out. Court did not go into the specifics of each survey number or the scheme.
No, the apex code has.
No, does not matter. Supreme Court says left out. Left out of what? It is left out of what? Left out of the scheme. Now, where is it? If it is there, it should be then in the scheme, then it is left out. Now, it does not mean now they cannot include every property, whether it is included in the scheme. The word itself says there is a scheme, you have left it out, and you did not acquire the property. When you yourself say that it is not a part of the scheme.
First time. A part of the scheme in 2012, there is a communication. Now in 2021, when the apex code directed issuance of preliminary notification.
It is
This
also
was
in,
included.
no, it was also in reference to the original scheme only,
No, this was included.
This was included in
In
the.
the. preliminary
not
notification.
included.
Preliminary notification. 2021.
ಯಾವಾಗಲೂ ಇಲ್ವೇ ಇಲ್ಲ. Only 22 ದಲ್ಲಿ for the first time.
2022 ಅಲ್ಲಿ first time preliminary notification include ಮಾಡೋದು.
ಹೌದು.
ಅದು that Supreme Court and directed issuance of final notification. ಎರಡು Supreme Court ಲಾಗೋ.
ಅಲ್ಲ ಆಗಿದೆ, ಬಟ್ ಇವ್ರು ಹಾಗಾದ್ರೆ ಯಾವ ಲ್ಯಾಂಡ್ ಬೇಕಾದ್ರೂ ಸೇರಿಸ್ಕೋಬಹುದು.
Alan, because BD in fact was supporting the petitions all through. It was pursuant to order of the Supreme Court we had to acquire. Because it is as we have issued this,
Whatever is
whatever is acquired is pursuant to the orders of this.
No problem. Sorry.
No, no. Why do we say that? We should say sorry to you. We are making you to argue. You know this account,
Seventh hacker.
seventh.
That answer. is-
Because we have to read again, this aspect again, we have to think and come back. But there are cases where despite direction by the apex court, you have considered and dropped the lands.
Committee.
Huh,
Committee.
committee, that's what. That has happened.
Before issuance of the 2022 prelim notification, there was a direction to BDA to conduct a spot inspection and to recommend to them which are the lands which can be further dropped without including in the 22 notification. There was a detailed inspection done by the BDA.
That was
submit
placed before the.
before the court.
Then
After considering that these lands to be dropped, there was a specific direction. Thereafter, this prelim notification came to be issued. So
Super BDA.
after the orders of Supreme Court, there was spot inspection conducted and there was a report submitted that these are the lands which can be acquired. That was taken into consideration. Then there was a direction to issue the prelim notification.
You'll have to have a look at the Supreme Court order passed on 12/7/22.
ಇಲ್ಲ ನಾವು ಇನ್ನೊಂದ್ಸರಿ ಓದ್ಕೊಂಡ್ ಬರ್ತೇವೆ.
We'll have it on.
We'll read again and come back.
System accord. ಜೊತೆಗೆ ನಿಮ್ದು ಬೇರೆನಾ?
But next date.
18th.
Same ಆಗುತ್ತೆ.
Seeking dropping of larger.
Issue is the same ಆಗುತ್ತೆ.
Actually, seeking dropping of larger extent, but they are all connected matters.
That's why.
Only the date of notification is different.
ಅವ್ರದ್ದು ಅದೇ.
Existing.
The adjacent land which is vacant to be allotted. To the extent that is going for the purpose of road, the playground itself is going to the purpose.
ಅವಾಗ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ? ಅವಾಗ ಹಂಗಿದ್ರೆ ಹೋಗತ್ತೆ.
ಇಲ್ಲ, alternate land.
The extent that goes limits to the road is allotted, it will come within the statutory limits for the purpose.
ಅದ್ರ ಅಲಾಟಬಿಲಿಟಿ ನೋಡ್ಬೇಕು.
But we have already formed sites. Now we want one entire extent of one complete stretch of land. We are ready to give sites. But to give, because sites have, we have taken position, sites have been formed.
Judgment ನಾವು ಮಾಡಿ.
ಇಲ್ಲ, altering entire topography there.
Yes. In fact, my lord, I have produced the map. There is a land vacant in the,
7th, we'll do.
in fact, committee, my lord, while dropping the.
Point, my lord. Anyhow, your lordships will hear another day, but there is only one line your lordship may see in this Supreme Court observation. Only the highlighted portion. Not a blanket direction.
Verification, feasibility.
But this Supreme Court has up.
Thereafter matter
put a
went,
seal.
thereafter matter went before the apex court subsequently.
No, but there, they have only said that examine the matter, whatever you have done, you can go. But the question is that there should be an application of mind in relation to this. The court does not go into the specifics of survey number and other things. They only say that you can go ahead and acquire.
7th.
Now it looks as if land.
We'll also look into it.
Very well. 15 also is a similar issue may be there, that also.
ಜೊತೆಗೆ
All 7th.
seventh.
My lords may mention what is the order of the Supreme Court, my lord. This copy is not served on.
ಅವ್ರಿಗೆ ಒಂದು ಮಿಸ್ಟರ್ ಹರ್ನಳ್ಳಿ ನಿಮ್ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲರ್ ಏನೋ ಕಾಪಿ ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಕೊಡಿ.
My lord, 11.2. This is the, after feasibility, this is the report, my lord, which was.
7 point.
Supreme Court, my lord, I was just mentioning it. Feasibility report was submitted and then.
Then orders were passed. ಎಲ್ಲ ಮಾಡಿ ಮುಗಿಸ್ಬಿಟ್ಟಾರು.
That's
That
11.2. my
amounts
lord.
to we interfering with the order of the Supreme Court ಅಂತ ನಿಮ್ ಸಜೆಷನ್.
Lots 11.2. One bit of land was regularized, my lords. Another bit of land is, please,
On 7, please.
interim orders, my lords.
12/7/22.
ಇದರೆಲ್ಲ synopsis ಹಾಕಿದ್ದೀರಾ?
Please. What we only want to insist on the court, the fact that it was not feasible for.
Supreme Court, the 12/7/22 ಬರ್ಕೊಳ್ಳಿ. And put out on the ಬರ್ಕೊಳ್ಳಿ.
Now, feasibility report was taken by the BD.
They have not placed it on
No.
record.
No, before the
Supreme Court.
apex court,
Before the Supreme Court,
Once
the
the direction was
and the Supreme Court has
The
said.
direction was very specific,
even otherwise,
that
how
if
can
it is
we?
feasible or not.
Saleh, too, can we examine whether this report was before the apex court and apex court did not look into? Once the stages cross, it should be presumed that everything is looked into by the court. Again, arguments in the middle is there. That is our problem. That cannot be.
Yes.
My lords, 11.1, my lords. 11.1.
I thought 7 to 11, same.
Obliged.
Yes, sir, yes. ಏನಿದು? ಮಿಕ್ಕಿದ್ದು ಅರ್ಥ ಆಗಿಲ್ಲ. Entry ಮಾಡಿದ್ರೆ ತಾನೇ.
Yes.
Senior engaged in other court, my lord.
The senior is in another court.
Date after 7th may not be clubbed with on that day. 7th, my lord, my lords may hear the 2022 notification.
Prakash is here.
Yeah, 7th.
11 ಆಯ್ತು. 11 and 7th ಹಾಕಿ.
Please, ma'am. In total, the
Okay.
issue is now it's a fully developed houses with the family.
Animal husbandry.
No, it's a different thing. And where I have built a small, because my financial condition also, that man, I have built in 30, 40, 60, small house. We are residing. Now, these persons are saying that you will regularize only that building.
ಯಾವ
About the,
ಬಿಲ್ಡಿಂಗ್ ಅದು ಎಲ್ಲ ಶೆಡ್. Come to 96 ನಾನು ನೋಡಿದೀನಿ ನಾವು.
ಮುಂದೆ ಇರುವಂತದ್ದು, my son is a software engineer and he has established a small industry. And so far as houses are concerned, my lord, there are one or two, this Anath Ashrama also are given, charitable, it is duly registered with the Karnataka state. And where I have left out to two sites to them, the old people and the disabled person, they can come and sit. No, those two sites are vacant sites, they cannot regularize is their answer. These are the peculiar situation where
ಯಾವ ಟೂ ಸೈಟ್ಸ್ ಅದು?
ಬಂದೆ.
ಇನ್ನು ಉಳಿದಿದ್ದೇನು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಯಾರ?
ಉಳಿದಿದ್ದು ರೆಗ್ಯುಲೈಸ್ ಮಾಡಿದ್ದಾರೆ.
ಆ ರೋಡಿಗೆ ಬರತ್ತ?
No, ma'am.
ರೋಡಿಗೆ ಏನ್ ಬರಲ್ಲ.
ರೋಡ್ಗೆ ಏನಿಲ್ಲ.
They had made 8 applications. 8 application ಹಾಕಿದ್ರೆ 5 regular.
16 ಹಾಕಿದ್ದೀವಿ. 16ರಲ್ಲಿ ಕೆಲವು 8 ಜನ ಮಾಡಿದ್ರೆ ಮಿಕ್ಕಿದ್ದು.
ಐಡೆಂಟಿಕಲ್ ಇದ್ದಂಗಿದೆ 11.
ಸೇಮ್
11 ಇದ್ದಾಗ ಇವನ್ ಮ್ಯಾಪ್ಸ್ ಆರ್ ಸೇಮ್.
ಇದು ಅಷ್ಟೇ, ಸುತ್ತ ಎಲ್ಲ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿ ಮಧ್ಯಕ್ಕೆ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ಬಿಟ್ಟಿದ್ದಾರೆ.
Committee
ಹಂಗಾಗಿ ಅದ್ರ
because
ಜೊತೆ join ಮಾಡೋಣ.
the direction given to the committee was to regularize dwelling houses. Now it's a vacant land. Now to recommend vacant land may not have been proper on part of the committee.
Now, what is the position of this land? How will you use it?
How can you
Also
make
not-
use of that?
How will you use it?
We
ನೀವು
also-
ಎಲ್ಲರಿಗೂ ಅಲ್ಲಿ ಸೈಟ್ ಅಲಾಟ್ ಅದನ್ನ ಡೆವಲಪ್ಮೆಂಟ್
Sir,
ಮಾಡ್ಲಿಕ್ಕೂ ಹೆಲಿಕಾಪ್ಟರ್
even otherwise, it's a revenue site.
No,
that's all right.
If it's a revenue site, then he has to go to the committee. It's a vacant revenue site.
that will- But
Now for all similarly held vacant revenue sites holders, there is direction to go there.
Yes, indeed, there.
Yes,
Only
They are going
asking,
practical,
previous point ಇರ್ತಾರೆ.
11.
ಸುತ್ತ regularize ಮಾಡಿ.
but this is 2 acres of land. Yes.
Concept. ಸುತ್ತ regularize ಮಾಡಿದೆ. ಮಧ್ಯದ portion ಬಿಟ್ಟು, because dwelling houses ಇಲ್ಲ. What is the status of that land? What is going to happen or how are you developing that? ಸುತ್ತ it is all land, it is as good as landlocked.
They are going to gain entry to that.
How do you get
Vehicles
it?
ಹೆಂಗ್ ಹೋಗ್ತಾರೆ?
Seek instruction of that, my lord, what the BDA has in mind to develop that extent of land.
Unless BDA owns some helicopter, something like that, heavy lifting.
In where my lord Mr. Harnelli had appeared, there is a road widening in the front. So probably my lord, the entrance becomes much larger. Thereafter, my lord, we'll have to, my lord, what is the status of that?
ಮಧ್ಯದಲ್ಲಿದೆ, ಸುತ್ತ regularize ಮಾಡಿ. ಏನು way out, how do you?
In the,
In fact, we may send him there,
yes.
but in such cases, how do you resolve?
Because my lord, Practically, my lord, nothing can happen apart from the fact that we may form a site. If it's a revenue site, we will have to form a site and then give the same site. Now, to give it to those persons,
Exactly,
they are
that solution. if
yes.
that Solution is there, we can pass.
please. Site
Nobody is helpful because
Please.
it's not then, should not be opening Pandora's box.
That is the issue, my lord, because many of them have purchased sites and have kept it vacant. Adjacent properties have been regularized. Those vacant sites have not been regularized.
So adjacent property where road passes through, no problem. It
Yes.
is completely circled by.
There are
Landlocked
several
is that-
most of the
landlocked.
cases, most of the people, my lord, who approach the Bopaya committee are those vacant revenue sites who have purchased sites, have not constructed anything. Now adjacent properties, they have constructed houses, they have been regularized, they are staying there. Now these homeowners, site owners, they are left in the dark.
Seventh rule.
Please, madam. I can understand if there is any road or anything, if they want vacant place,
That's what.
Yes.
check. That's what.
ಈ ಹೆಸರು ಮಜಾ ಇದೆ ನಿಮ್ ಫರ್ಮ್ ಹೆಸರು.
My lord,
ಯುವರ್ ಫರ್ಮ್ ಲಾ ಫರ್ಮ್ ನೇಮ್ ಓದಿ ಅಲ್ಲಿ ಪ್ರಿಂಟ್ ಮಾಡ್ದಂಗೆ ಓದಿ ನೋಡೋಣ. ಜನಾರ್ದನ ಅಂಡ್ ಜನಾರ್ದನ ಇಬ್ರು ಸೇರ್ಕೊಂಡು ಮಾಡ್ದಂಗಿದೆ.
ಹೌದು, ಹೌದು.
ಜನಾರ್ದನ ಈಸ್ ಒನ್, ಜನಾರ್ದನ ಈಸ್ ಅನದರ್.
ಇಲ್ಲ, ಇಬ್ರು ಜನಾರ್ದನ ಇದೆ. ಇಂಗ್ಲಿಷ್ ಹಾಕೋಲ್ಲೇ ಅದಾಗೋದು ಇಬ್ರು. ಅಪ್ಲೈಸ್ madam.
Petitioners will to file objections. Ready ಮಾಡಿಲ್ಲ ಏನಕ್ಕೆ ಮಾಡಿಲ್ಲ
Based on seventh objection.
Fresh matter, my lord, prayer is for consider representation.
ಯಾವುದು?
Serial number 14.
Consider representation.
Application representation.
This is the same as that of 11 minutes. Your lordship will
22
fix
notification.
7th.
Along with.
Petitioner. 22 notification left out.
Vacant land, same as Mr. Harnally.
11.
22 note. There's one 22 notification matter which has been reserved by this honorable court. Yes. Seventh.
So this is a road matter. The distinction, my lord, is that I'd set up a petrol pump here. Petrol pump.
But protection is only for residential units.
It's a lot dispose it, my lords, let BDA take, my lords, their action. If, my lords, they think it fit, my lords, that in terms of,
You submit a representation.
I'll submit a representation.
ಎಷ್ಟು ಇಂಥವಿದೆ ಪೆಟ್ರೋಲ್ ಬಂಕ್ಸ್ ಎಲ್ಲ ಏರಿಯಾದಲ್ಲಿ?
There are around 10 sites, my lord, over the measurement of 10 guntas. 10,000 square feet.
Each
Yes,
2.5 ಎಕರೆ ಆಗ್ತದೆ.
yes. So, most of them are not regularized.
Not regularized. Any one is regularized?
One structure has been regularized
Why?
because it had come up earlier to the date of notification.
Then the same treatment has to be given to these people also.
Mine is
If
regular,
can be. It's a regularized also, but it comes in the way.
regularized.
That stands on a different foot. Maybe that the one which you are mentioning, the road did not intrude.
That time, my lord.
Here it does. Road intrudes.
Now, my lord,
Consider.
We will give a representation.
ಒಂದು representation ಕೊಡಿ ಬೇಕಾಗೋ ಇನ್ಫಾರ್ಮೇಶನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಕೊಡಿ.
With all embellishments you can give.
It's my only request, Lords, let them consider it in the light of what your lordships have passed itself in other road matters.
No, that was not a case where road was coming in. That also can.
Those are.
please.
In the light of that judgment, we can give a representation. That they will consider.
But I think in the light of the recommendation of the committee, you reject it if you want. You can reject my.
ಅದು ನಂಬರ್ ಯಾವುದು ರೋಹನ್ ನಂಬರ್
Please, minutes. I'll pass it.
The petitioners are before this
Where is
court
the other copy?
taking the following. The construction of pursuant to the notification of acquisition. The petitioner had approached the committee constituted by the apex court hyphen A.V. Chandrasekhar committee, seeking regularization of the construction. The regularization, the committee opines that the construction can be regularized. But the situation now is that the road passes through the construction of the petition. Of the property of the petition. Therefore, the regularization that is made has become of no avail to the petition. Identical cases which had projected somewhat similar circumstance have all been decided by this court by the following order. The learned counsel for the petitioner submits that if an order of the, submits that he would submit a representation to the respondent BDA, venting out his grievance that has been projected before this court in the subject petition. And if the BDA would consider the representation of the petitioner in the light of the order passed on 4th December 2024 would suffice for the present. The learned counsel for the BDA submits that the representation, if would be submitted by the petitioner, would merit consideration and necessary orders would be passed in accordance with law as in accordance with law. For the aforesaid reasons, the following. In the light and said submission, the following one. Petition disposed, the petitioner shall submit a petitioner, if so desires, shall submit a representation to the respondent BDA within 2 weeks, from the date of receipt of the copy of this order, and the BDA shall within 6 weeks thereafter consider the representation and pass the necessary orders in accordance with law, bearing in mind the observations made by this court in writ petition 14082 of 23 disposed on 4th December 2023, and a decision taken thereon shall be communicated to the petition.
I may be protected till the
Till the decision is taken by the BDA, status quo where the property be maintained by the.
The order passed by this court, there's already a protection. We have to issue them notice and to vacate that.
Anyway,
Yes.
that is protected.
Till that. This court, in terms of its order dated so and so, had directed parties to maintain status quo. That order will continue till the decision is taken by the BDA as observed by us here.
Please. Grateful, Mr.
The appeal for the. Yeah.
Not I appear for the petitioners.
19, all serial vacant sites, not similar to serial number 12. All are
12.
vacant. Yes, where Mr. Shivprakash had appeared.
ಇದು ಲ್ಯಾಂಡ್ ಲಾಕ್ ಸರ್.
Lord, what has happened in this particular case is,
Well, is it a case of landlock?
Not landlocked, there is
Landlocked.
independent
not a
access to
case
road,
of
but the
landlock, but
adjacent
my lord, it
buildings have
is
been
the
regular.
extreme end of the acquisition. Not layout has been formed, my lord, approved layout has been formed during the year two
Just show, my
thousand
lord,
four.
the
Sale
layout
deeds
map.
have taken place, my lord, 2004.
I'll produce it by way of memo also. Now the highlighted portion are the petitioners. Adjacent to, yes.
My lord,
Adjacent landowners, site owners have, houses have been regularized. Now they're seeking, my lord, even if the possession is taken of their property, we also may have to form a site and hand it over to somebody else. Rather they give it to them is what they're seeking.
my lord, on the last date of hearing, my lord, on physical please, my lord. On the last date of hearing, my lord, on 10/1/2025, my lord, a colored sketch has been produced before the court. Not, your lordships would see, my lord, there are 3 survey numbers that is involved. My lord, insofar as this particular blue portion, my lord, that is now used for widening the road and forming a channel. And at the extreme end, my lord, your lordships can see survey number 70, 71, 72 on the extreme left side, my lord. This is freshly formed by the BDA. Now, what was available earlier, my lord, is the remaining portion. Therefore, my lord, this particular portion which was available to the BDA, they have, my lord, integrated with the existing layout. Now, we are all site persons, my lord, who have purchased, 34 of them, who have purchased, my lord, 2004, 2005 sale deed. Prior to getting the land converted, my lord, an application is made to the BDA to verify whether this has been utilized for acquisition purposes. They issue an endorsement saying that it's not utilized. Subsequently, 2004, 2005, it starts, all of them are having registered sale deeds, except please.
Property, which sub-registrar you went to, which bank you borrowed money from. These are not the argument. Now the question is only what, in the light of what we have already decided.
Please.
ಆ parameters ನಲ್ಲಿ ಇರ್ಬೇಕು. Argument ಮಾಡ್ಬೇಕು.
Please.
appear for the petition, my lord.
Last time,
Please, my lord, my lord, one request, my lord. In same survey number, the Google map shows, my lord.
ನಾವೇನ್ ಕೇಳಿದ್ವಿ? Twice we had made orders.
Please, my lord, but what, ಬೋರ್ವೆಲ್ ಮಾತ್ರ ಹಾಕ್ಸಿದ್ದಾರೆ. ಇದು ಆ ಟೈಮ್ ನಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಲೇಟ್, ಲೋನ್ ಸ್ಯಾಂಕ್ಷನ್ ಲೇಟ್ ಆಗಿದ್ದಕ್ಕೆ 2018 ಎಂಡ್ ಅಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. 2020 ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು. ಹಾಗಾಗಿ ಇನ್ ಟೈಮ್
You undertook also.
ಪ್ಲೀಸ್
not once but
Twice.
please my lord.
So,
But the fact is that
next time if nothing is there, we are going to close.
We had put to caveat also.
my lord, one submission, my lord. The Google map shows, my lord.
Used to complain about it. You want to look at it.
On the risk. Yes.
My lord, the loan sanction ಆಗಿದ್ದು ಲೇಟ್ ಆಯ್ತು. ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಹಾಕಿದೀನಿ. ಲೋನ್ ಸ್ಯಾಂಕ್ಷನ್ ಲೇಟ್ ಆಗಿದ್ದಕ್ಕೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಲೇಟ್ ಆಯ್ತು. ಬೋರ್ವೆಲ್ ಹಾಕೊಂಡಿದ್ವಿ. ಹಾಗಾಗಿ ಇದು ಇದಾಯ್ತು.
Very ingenious lawyer you are.
My lord, ಅವರು
How that's going to, we assume that is true.
she is a widow, my lord. She could not mobilize the funds immediately.
ಅದು widow one of the factors ಆಗಿಲ್ಲ ಯಾವುದೇ judgment.
My lord,
Structure, no structure.
one more submission, my lord. In the Google map shows no building anta. In the site number 49, site number 72, ಅವರಿಗೆ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಮಾಡಿದ್ದಾರೆ. ಸೇಮ್ ಲೈನ್ ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
ಒಂದು representation ಕೊಡ್ತಾರೆ.
Please. I will.
ಮತ್ತೆ ಅಲ್ಲಿಯೂ ಮತ್ತೆ ಇದೇ ರೀತಿ ಮಾಡಬಾರ್ದು.
ಇಲ್ಲ
ಏನೋ ಸ್ಟೋರಿ ಹೇಳೋದು.
Please.
ಲೋನ್ ತಗೊಂಡು
The petitioner is before this court seeking the following prayer. owing to the contention of the petitioner that the structures had come up, that's one side. The structures in the subject property were in place prior to the issuance of the, prior to the cutoff date as directed by the Apex Court to be 3/8/2018. This court had passed several orders directing evidence to be produced before this court with regard to the construction and statutory compliances taken towards the said construction. The orders passed.
10-1
2020 notification ಮೆಮೊ ತರ ನಾವು ರೆಡಿ ಮಾಡಿದ್ವಲ್ವಾ
10-1.
ಏನ್ ಹೇಳಿ ಆರ್ಡರ್ಸ್ ಅವು ಇವು ಏನೇನೋ
Even today, the
Clear.
petitioner has not produced any document as was directed, but submits that the loan was not sanctioned within time, therefore the cutoff date had skipped by then. And would submit that a representation, he would submit a representation enclosing all the documents to the PDA. And in that light, the learned counsel Shiv Prasad Shantangod submits that documents are placed, they would be considered and necessary orders would be passed in accordance with them. That light, we deem it appropriate to dispose the petition, permitting the petitioner to submit a representation to the VDA, enclosing all necessary documents as he is wanting to do, or as he still wanting, which is all the documents. The VDA shall consider the representation thereon within 2 weeks.
Within 2 weeks.
The petitioner is thus permitted to submit a representation within 2 weeks from the date of receipt of the copy of the order. The VDA shall thereafter, within 4 weeks thereafter, consider the same and pass necessary orders in accordance with law and communicate the decision taken to the petitioner. It is made clear that we have not entered into the merit of the claim of the petitioner.
Till that protection.
Till such time, the interim order subsisting shall continue to be in operation.
If the petitioner is
ರೋಡ್
ಒಂದು ಪೋರ್ಷನ್ ರೋಡ್ ಇದೆ, your lordship may kindly just take minutes. Page 6 of my petition, just for one moment. ಇಲ್ಲ, ಒಂದು ರೆಗ್ಯುಲರೈಸೇಷನ್ ಆಗಿರ್ಲಿಲ್ಲ. So therefore I have sought for another prayer. But insofar as seeking regularization of that property, VDA has filed their statement of objections, stating that I, have filed a second application and that property has already been regularized. Therefore, apart from the issue relating to the road, the property which has not been, by which my application has been rejected, but in the earlier one which has been regularized, but direction could be issued that the certificate may be issued to us, and the petition itself would be disposed.
because in the order, my lord, which learned AG made a mention, pursuant orders of the court only thereafter, my lord, we can issue the regulation certificate. Because if it is regularized, the data is before your lordships. Once the order is released, my lord, we have no objection, my lord, in issuing the regulation certificate. They are 105.
Regularized agide. Our orders are with you. What is that they have to do?
Nothing, my lord, because certain places or buildings have been regularized, but however, we have not get any confirmation saying that it has been regularized. The message directly goes to them. Only once it is approved from the Supreme Court, my lord, we would get the information.
Yeah.
Now we can dispose this.
Yes. With the direction to issue regulation certificate, we'll comply. With respect to the
regularized.
If it is regular.
Name is that it is regularized.
Well, my claim is,
Produce all those documents of regularization to the BD or they have it.
you lords kindly take the statement of objections, page 4, para 9.
Admit ಮಾಡಿದಾರಾ?
Yes.
Admit, ನಾನು by
Regularize ಆಗಿದೆ.
ಆಗಿದೆ ಅಂತ.
Then issue
Yes.
of certificate.
Yes, there are multiple structures. Some of the structures fall on the RMP road. That for that, my lord, the earlier judgment will apply. With respect to structures where RMP doesn't go, those will be protected pursuant to regulation certificate being issued.
Same,
Same order,
same model. pass.
only one direction.
Regulation certificate they will give.
Yes, madam.
Adonta.
The petitioner is before this court. Petitioners are before this court, seeking the following prayer. Inter-alia, the prayer that is sought by the petitioner is for issuance of a regularization certificate for the extent of the property that is regularized. The BDA in its statement of objections would accept the fact that certain structures in the property have been regularized by the commissions of a regularization certificate which recognizes the regularization of the property of the petitioner. Therefore, the BDA shall within 2 weeks.
2 weeks.
Within 2 weeks, issue a regularization certificate to the petitioner of such property that has been regularized. Insofar as the other prayers are concerned, the petitioner is at liberty to submit a representation to the respondent BDA. And the BDA on such, within 2 weeks from the date of receipt of the copy of the orders. The BDA shall, within 4 weeks thereafter, pass necessary orders on the representation so submitted by the petitioner, which is, so submitted by the petitioner. Then the
In the light of this order,
representation should be submitted in the light,
same.
same order. 4th December 24 dispose of it. 4th December. Submit a representation and the BDA shall consider the said representation bearing in mind observations made in the order dated in the petitions posing to committee open within 4 weeks thereafter. Until such time, the interim order subsisting in the case of.
Please. Great.
ಎಲ್ಲ ಅದೇನಾ?
No.
Illa, ಬೇರೆ.
22, my lord, I seek some time. The objections are yet to be read. Seal number 22.
Council Shivaprasad Shantangowda seeks 22 only, seeks 2 weeks time to file statement of objections. Objections if any by the next date, list on 7th.
Please.
On 7th, my lord, they are also seeking dropping of larger extent of land.
List on 7th. Statements ಹಾಕಿದ್ದೀರಾ?
No, my lord, seeking.
Takes 2 weeks time to file statement of objections, list on 7th. Interim order will continue.
Road.
This is a road matter for an education institution.
Intended.
ಇಲ್ಲ ಕಟ್ಟಿದ್ದೀನಿ functional running
Yes, sir.
3 acres 14 guntas minutes was regularized.
On the ground that school is running.
School is running.
Now that road is passing, my lord,
Road passes through.
road passes.
What happened was initially they formed a road.
Map ತೋರ್ಸಿ, number. ಎಲ್ಲಿ ಹೋಗುತ್ತೆ map ಅಲ್ಲಿ?
School is running.
School is running.
Objections ಹಾಕಿದ್ದೀರಾ?
No, my lord. It's short instructions, but the road is passing through. That is admitted.
The objection
School running ಅಲ್ವಾ?
Not on the school premises, on the vacant land
That's
adjacent to the school.
so what has
It has been
happened.
regularized.
Your lordship's minutes have produced.
School has been regularized.
School has been
School,
regularized,
there's
the
no dispute with
adjoining area
respect
also
to
has
that.
been regularized. The adjoining vacant land, my lord, the road is passing.
Vacant alla, kindly see page 52 minutes. It's not a vacant land. Then the compound
Objection,
security room.
Objections.
2 weeks same. Objections if any by the next date, 7/2, interim order.
I had minutes filed a civil suit in this regard minutes and I had undertaken to withdraw the civil suit in view of, please minutes. I've done.
ಅದು ಮೆಮೋ ಹಾಕಿ.
Memo al haq. Please.
Let it be on.
Seek some time.
Interim order.
Yes.
Objections.
Interim order.
Same 2 weeks. Spent.
Full matter.
ಅದು ಜೊತೆ ನಂದು ಟ್ಯಾಗ್ ಆಗಿತ್ತು.
Okay.
Because ಇದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು, ಎಕ್ಸ್ಕ್ಲೂಡ್ ಆಗಿತ್ತು. ರೆವೆನ್ಯೂ ಸೈಟ್ ಹೋಲ್ಡರ್. Your revenue site holder judgment ಹೇಳಿ ನಾನು ಒಂದು ರೀಸೆಂಟ್ ಕಮಿಷನರ್ ಕಮಿಷನರ್
ಯಾವ್ದಿದು? I think we consider them carefully, we find that issues.
appear for the FL. Pass and synopsis.
Ready. Ready. Ready.
Where the response. Whereas the respondent filed a suit for declaration and permanent injunction. My lord, on 9/4/2012. My lord, 11/12/1996, the scheduled property was granted in favor of the appellant's husband, that is Srinivas. Then there is an agreement on 25/2/2008
It was a suit for
Declaration
declaration and
and
injunction.
injunction on the basis of the sale deed.
Ah.
My lord, there was an agreement on 25/2/2008.
Defendant's husband was the grantee,
Husband, yes.
grantee. Grant under which law?
General land grant rules.
1996.
Yes.
Whether grant order is marked in evidence?
It is not marked.
Not marked.
Not marked. There is a non-alienation clause for a period of 15 years in the grant.
Ah.
Then 25/2/2008 is an agreement came to be drafted. The said agreement was registered on 27/1/2009. Then my lord, on 25/2.
What is that? Some agricultural land?
My lord, he was looking after for purchasing some agricultural property.
That way.
That agreement, this 25/2/2008 agreement was, which was drafted on 25/2/2008, came to be registered on 27/1/2009.
Agreement is registered,
Ah.
not sale deed.
Not sale deed. Okay. Then my lord, there was a GPA as per exhibit P.
Adu registered GPA.
Adu no, it was drafted on 27/2/2008, but was registered on 27/1/2009.
Drafted on
27/2/2008.
Registered on
27/1/2009.
more than 8 months.
Agreement as well as GPA were registered on the same day.
Again. Under Registration Act, 4 months, within 4 months, it should be presented for registration.
Yes, madam.
And maximum is 8 months.
8 months.
4 plus 4.
Yes.
But how many months it will be?
It is beyond 1 year, madam.
How it came to be registered?
It ought not to have been mailed, but it has been registered.
No, at not only, it's already registered.
Yes, madam.
Whether
Sir,
effect of registration beyond the period of 8 months, what Allahabad High Court said. Optionally. It was presented in time?
Not in time, madam. Rashma kindly say, madam. Agreement drafted on 27/2/2008, registered on after 11 months. 11 months. What? 11 months. 11 months, madam. After lapse of 11 months. It should have been within 4 months. It should have been presented.
We're asking you one more question to you now. Where an instrument, a document, the Registration Act uses the word document, Stamp Act uses the word instrument.
Instrument.
Anyway, we'll not much bother about it. There are some consequences, we'll tell you. A document which is compulsorily registrable,
17.
for that it is 4 months plus 4 months.
8 months.
8 months. Whether an optionally registrable document, whether there is such a limitation or not, is the question. What's your answer? Do you agree that there is difference between these?
There is. These documents
A
are, need
document
not be
is-
registered. These documents need not be.
Therefore, where a document is compulsorily registrable and not so registered, then intended transaction does not come into effect.
Yes, ma'am.
49 48 ಅದೊಂದು ಸೆಕ್ಷನ್ ಇದೆ ಆ ರೀತಿ. Where a document is optionally registrable, can it be registered after the expiry of 4 + 4 months? That is the question. Related question is also there. A document which is not compulsorily registrable, if registered beyond the period of the prescribed so and so, there is one lone judgment which says document itself becomes void. So you want to argue or you want to prepare and come back?
I will prepare it, come. Half model bit.
All right. Call this matter when this bed exceeds. Come on, at the request of the senior advocate appearing for the appellant. Done.
Date may be.
Date meeting, now yavat purti brother should be free, I should be free. I am in bench, of course, brother is not presently, maybe he is also maybe in the bench. Many matters sit up. Bench, he is also in bench. So, all right.
My lords, kindly, my lord.
Ah.
I appear for the third respondent, my lord.
This,
In this appeal, my lord. It is for the society. Society has also filed a suit for specific performance, which came to be dismissed. I am
you
before this.
also appear in this matter?
Yes, ma'am.
That matter may have to be linked along with this one. That is RFA
If
number.
I'm not mistaken, that was already disposed of, that suit. There is no appeal pending, minutes.
Which one?
Against the said.
Society,
Appeal is
there
pending.
was a compromise that was entered
No,
into
no, no.
between them.
Appeal is pending.
Till RFA 595 of 2019, it is pending. Okay.
It is pending.
Please, my lord, Sarvanam.
Mr. Devdas also has come wait. ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಪಡ್ತದ?
Same.
ಅದೇ ಅದಕ್ಕೆ?
Pardon, ma'am?
That suit was for what?
My suit, society suit was for specific performance which came to be dismissed.
This is a suit for declaration injunction, so I
Ah.
think the
Same
relief
survey
also
numbers,
are different.
Yours is a suit for a specific performance.
Same survey number.
Huh?
Same survey number.
Maybe. This, your suit is for
Declaration injunction.
declaration and injunction. Are you agreeable that the result of this suit shall be subject to the result of their appeal? Even otherwise, that will be that way.
Even otherwise, it would be.
Therefore, need not be held together at all. In specific purpose.
Please, my lord.
It is because go to specific purpose, you will get.
Would only request, my lord, because it is being listed today.
No, it cannot be.
Oh, my lord.
This is,
I do agree that let it not be tagged along with that.
it need not be posted at all.
Please. I'm
Yes.
not that man. Please seeking a short accommodation, reason being listed today. The society wants to engage the services of a.
No, we'll give you time. Let them start. Then on the sari mugiyala, so complication ಇದೆ.
Please, please.
We'll start
Please, ma'am.
that way with that. Yes.
But in the first appeal,
ಹಾ. ಎರಡು appeal ಏನಿದು?
there are two appeals.
ಹಾ.
Blood. The first appeal 885. Where is mine?
Yes, ಕೊಡಿ.
Blood. This is a suit for declaration and injunction.
Ah.
At the last occasion of hearing, your lordship was pleased to dictate some notes also.
OS number
OS number 15-253 of 2005, my lord.
5253.
15-253 of 2005. This is the
For
subject matter in
declaration and
RFA
injunction.
number 885.
Huh?
RFA number.
ಅಲ್ಲ, 1 second. ಇದೆರಡು ಇದೇ ಸೂಟ್ ನಿಂದನೇ ಬಂದಿದೆ. Both. appeal and cross objections arise out of the same judgment.
No, no, not, that is not the, two different
Ah,
suits.
different
Two
suits.
different suits and two different.
OSA
appeals.
5253 of 2005 is for declaration and injunction.
And injunction filed by, my lord, 6 persons,
Who are
6 persons who claim to be the sons
ಅಲ್ಲಿ
of,
ಇಲ್ಲಿ ಯಾರು ಅವರು respondents.
out of 6, my lord, that's why I'm saying.
Ah.
One M. Nagaraj, my lord, who is plaintiff number 5 in this suit, he is the plaintiff in the other suit relating to, my lord, RFA number
ಅದು connected.
684 of 2019.
ಈ appeal ಹಾಕಿದವ್ರು ಯಾರು?
My lord, these are the defendants' appeal.
Defendants appeal.
Defendants' appeal. Both the suits have been decreed.
Another OSCs,
OAS is, my lords, 3235 of 2004,
3235
of 2004. In respect of which, my lord, this RFA number,
this is for
my lord, first, my lord,
declaration.
was filed for
Two different judgments.
two different judgments,
two different
injunction.
judgments. This is for what?
My lord, this is for bare injunction.
Okay.
First, my lord, when the suit was, my lord, filed on 4/5/2004, this suit is, my lord, is filed only by the
Filed
fifth
on
plaintiff in the other suit, M. Nagaraj,
4/5/2004.
2004.
This is
That-
by few
Filed
of the
by-
plaintiffs in the other suit.
Only one plaintiff,
One
M.
plaintiff.
Nagaraj. M. Nagaraj, plaintiff number 5 in the other suit.
Okay.
My lord, when the suit was, my lord, filed on 4/5/2004, only one prayer is relating to, my lord, that is permanent, seeking permanent injunction, restraining the defendants, that is, we are the appellants. My lord, their agents from interfering with the peaceful possession and enjoyment, not a suit for declaration, only for permanent injunction to restrain the defendants from interfering with the peaceful possession. Later, my lords,
Amended.
the suit was amended after,
Date
almost,
of the amendment here.
my lord, on 19/2/2014, after a lapse of 10 years. Additional prayer, my lord, as per the amendment sought for, just kindly look into the plain there,
Page 9.
my lord, page 9 in RFA number 684/2009.
9.
Six 84. How, my lord, in the first instance, only one of the members of the family, though there are 6 as per the other suit, files only a suit for permanent injunction on
4/5/2004.
4/5/2004.
You said
Then
that.
after lapse.
When amended, date of the.
Amended during the pendency of the other suit, which was filed in 2005. The other suit is, my lords,
ಹಂಗ ಬೇಡ, date ಹೇಳಿ. When
date of amendment, my lord, is
ಅಲ್ಲ, ಅಲ್ಲ.
19/2/2014.
date of amendment application.
Date of amendment application,
ಯಾವಾಗ
my lords,
ಮಾಡ್ತಾರ ಅಂದ ಅವ್ರ ಕೈಯಾಗಿರಲ್ಲ ಇವ್ರ ಕೈ.
amendment application.
When it was filed, amendment application was filed on which date? ಯಾವಾಗ amendment allow ಮಾಡ್ತೀವಿ ಅನ್ನೋದು
As per
ನಿಮ್ಗೆ ಏನ್
this
control
amendment,
ಇರ್ತದೆ? Judges
my lords. My lord, IA for amendment is, my lord, on 11/2/2014. 11/2/2014. But there are certain common facts are there, my lord. When I narrate the common fact, my lord, in the first instance, just I want to draw your lordship's attention only to the prayers in the two suits. IA for, my lords, amendment was made on 11/2/2014. Amendment is allowed on 19/2/2014.
The next week.
Even prior to this amendment, my lord, Earlier also the plaintiff had filed similar application which was rejected for amendment and it was confirmed in the High Court. I will give the details later. But the amendment my lord allowed is AA, that is issue mandatory injunction directing that second defendant to demolish the illegal and unauthorized constructions raised on portions of the suit schedule property and hand over vacant possession of the same in terms of the undertaking affidavit dated 8/7/2005, filed in MFA number 3230 of 2002, connected with MFA 9392 of 2004 by the second defendant before the Honorable High Court of Karnataka. This is the prayer. Well, in relation to this prayer, which is allowed by way of amendment, no pleadings are there. No pleadings. Why this amendment has to be made? Why this amendment has to be allowed? No pleadings, no pleadings. Only the prayer is amended. Suit prayer is only amended. This is the prayer. My lord, all the amendments in that suit filed by Nagaraj, my lord, in relation to only relating to permanent injunction restraining the defendants on the basis or on the claiming that he is in peaceful possession and enjoyment of the land. Now with the amended prayer, the entire, my lord, the nature of the suit changes. He admits that the defendants are in possession to seek this prayer to demolish the unauthorized construction put up by them. If he were to be in peaceful possession and enjoyment of the suit schedule property, how the defendants would have put up. So the very basis for the suit claim goes, it has to disappear. Suit itself has to be dismissed on that ground. In relation to this prayer, there is no averment at all. But prayer can be sought only on the basis of the pleadings. No pleadings, sir, as far as this prayer is concerned. Just because in relation to other suit, my lord, certain proceedings relating to MFA came up and there by way of certain undertaking is given, that is sought to be, prayer is sought to be amended.
What is that MFA?
MFA, my lords, that your lordships will get. Undertaking, my lords,
What was the stage of the suit when amendment application was moved?
evidence was over.
Evidence was over.
Earlier, my lord, earlier also, my lord, IA number 25 was filed.
That was filed, your second
By
time you are
the-
saying, what was the date on which IA number 25 was filed?
IA number 25. Synopsis.
9293 of 2004 is MFA.
Please, sir, 2004, yes.
And there is another MFA 7628 of 2004.
Yes, 76.
7628 was in respect of rejection of injunctive relief.
Yes, a temporary injunction was my lord, rejected. In relation to that, MFA came. But this IA for amendment.
When was that IA filed? When it was rejected?
Please, sir, I am giving. That IA, earlier application for amendment is disallowed, dismissed. That one. Let in the other 6/4/2013 minutes.
IA
In
number
OS number 3235, IA number 25, filed under order 6 rule 17 for
25 of
6/4/2013 is the date. 3235, the other suit. The one which your lordship was looking.
Yeah.
3235.
IA 25.
25.
Ah. Filed, filed on,
filed by the plaintiff,
filed on,
filed on, IA 25. That was dismissed on 6/4/2013. I'm just. No, that is the date of dismissal of the. My lord, that was made on. Well, that is 15/2/33, nearly 30/35. I'm referring to IA number 25 in
IA 25 was in the very suit,
30/2/35 of 2004.
5253 of 2000.
That, which was rejected, dismissed on 6/4/2013. Then, my lord, that was challenged before this honorable court in WP number 22/914 of 2013. But
This, all this happened in OS 3235.
3235
In OS 5223, pleadings remained intact.
pleadings are.
There also, they were not amended.
Oh, there.
6/6/2012 was the amendment.
Please, madam, I'm so sorry. In fact, we have prepared the synopsis in the sort of both the appeals. There was a little correction, so my lord, that is the reason I not filing. My lord, take it, my lord, I got that. Thank you.
ನಿಮ್ಮಲ್ಲಿ
6/6/2012.
ಏನು ಸಿನಾಪ್ಸಿಸ್ ಇದೆಯಾ?
Copy ಇಲ್ಲ, some corrections ಮಾಡಿದೆ, but 6/6/2012, my lords. IA number 25 in OS number 3235 of 2004 was made on 6/6/2012. Then, my lord, that was
ಅವರು ಅದನ್ನೇನು ಅಮೆಂಡ್ ಮಾಡಿದ್ರು?
amendment, same amendment. IA number 25 ಇದೆಯಾ copy?
IA number 25 ಪೇಜ್ ಹೇಳಿ. ಮೊದಲಿನ IA ನಂಬರ್ ಏನದು? 11/2/2014 ಹಾಕಿದ್ದ IA ನಂಬರ್ ಏನು?
IA number 25, copy is not produced. But records nalide, but from our records, my lord, we have prepared the 6/6/2012 file, and it was dismissed. On the ground, my lord, the evidence of the parties was already complete. 6/4/2013, trial court dismissed, rejected. Against that, my lords.
What was the amendment?
Please, my lord.
What was the amendment sought for?
Amendment sought for, my lord, IA number 25 is the same amendment. My lord, that your lordship will get in page 385, in which appeal?
Is
That
it,
appeal.
is
30 to
it,
35.
is it your case that
Three,
the amendments could not have been allowed?
please.
Then it was incumbent upon you to produce the applications. If you want to, because under order 43,
Please.
Rule 1 capital A as amended by CPC, it enables you
Please.
to take up a ground that the application ought not to have been allowed because of the amendment. You need not separately challenge that order. Ground,
My lord, in the grounds,
could
my
have
lord, that could be.
to treat that ground, pleadings have to be clear. That will be able to decide only if applications and objections are filed, not otherwise. ಹಂಗ್ hold ಮಾಡ್ಯಾರ coordinate bench ಅದಕ್ಕೆ.
Subsequently, because that order of, my lord, rejecting the amendment, my lord, sought in IA number 25 was challenged in WP number, and this honorable court, my lord, dismissed the WP.
On merits,
That is,
on merits are it allowed challenge after the decree is passed. On what ground it is dismissed?
my lord, on the ground of the order. My lord,
Ground
it was dismissed on the ground that as on the date of filing the application for amendment, evidence is completed.
on merits it was
On
dismissed.
merits. Right? Then, my lords, that was challenged by the plaintiff, my lord, before this honorable court in WP number 4423/2012.
You said rejected on IA was rejected on,
253.
IA 25 was rejected on, WPL irat nodi. WPL irat nodi.
Please, please.
WPL order dated is nodi.
The
ಅದು
order ಇದೆ 4/1/2006, but in the suit, same.
It cannot be 4/1/2006.
19/6/2000.
How can that
Against
be?
this one.
You have filed the application on 6/6/2012. It has to be subsequent to that, maybe in 2013.
4/1/2016. 4/1/2016.
Ah,
OS you have got wrong.
Sir, you are looking at the question.
4/1/2016. WP also dismissed. WP number?
One second, my lord.
ನೀವು WP date ಕೊಟ್ರೆ ಏನೋ mostly. Longevity ನೋಡಿದ್ರೆ ಹಂಗ ಅನಿಸ್ತದೆ.
WP number, my lord, sir. That is not the number. But WP number 22/914 of 2013,
WP
that was
22,
dismissed on 19/6/2013.
22,
22/914, 22,914 of 2013. Am I right? Sir.
dismissed on
19/6/2013.
19/6/2013.
13.
Then IA would not have been rejected on 4/1/2016.
Yes. No, 4,000, that is a different. That your lordship may not take it. Then, my lords,
ಆ ಡೇಟ್ ಹೇಳಿ. ಆ WP ಕಾಪಿ ಇದೆಯೇನೋ ಆರ್ಡರ್ ಕಾಪಿ? WP ಆರ್ಡರ್ ಕಾಪಿ ಇದೆಯಾ?
I'll place it.
I will place.
all right.
After that, my lords, the plaintiff again filed, my lord, IA for amendment, that is IA number 29.
One more IA.
One more IA.
You said IA 25 was filed earlier.
25 was filed earlier for
Ah.
amendments, that was rejected on the ground that evidence was complete by that time. And that is confirmed, that order is confirmed by this honorable court in WP 22/914.
Correct.
By its order dated 19/6/2013.
Hmm.
Later, my lord, they came up with IA number 29
That
on
was-
11,
11/2/2014.
11/2/2014. Alla, the order,
No, date of filing of
Ah,
the application.
order allow ಆಗಿದ್ದು
IA dated IA 29,
28/2/2014.
IA number 28 or 29?
29 minutes.
29.
29. Please to allow, this is the date allow, when it was filed.
11/2/2014 is filing date. 19/2/2014 came to be allowed. Very ಏಳು ದಿವಸದಾಗ allow ಮಾಡಿ ಅಷ್ಟು fast
That is
ಕೆಲ್ಸ.
11/2/2014, it was allowed by the trial court. 11/2/2014,
19/2 ಅಂತ ಹೇಳಿದ್ರಿ ನೀವು. Filed on 11/2,
filed on.
came to be allowed on 19/2 ಅಂತ ಹೇಳಿದ್ರಿ. ಅಷ್ಟು ಬೇಗನೆ ಮಾಡ್ತಾರ.
That's why, my lord, I apologize to your lordship
Ah.
that the synopsis that we had prepared is not
Not correct.
not fully. That's
All.
But that was IA number 29, my lords, was allowed by the trial court on 11/2/2014 order. Then trial court permitted the defendants to file additional written statement. Then, my lords, again, my lord, after this
Additional
amendment,
written statement
20
or it was amended written additional WS. You are right.
amended,
Issue frame ಮಾಡಿದ್ರಾ?
ಏನ್ ವಿಷಯ ಇಲ್ಲ.
Additional issue frame ಮಾಡಿದ್ರಾ? ನಿಮ್ WS ಫೈಲ್ ಆದ್ಮೇಲೆ?
Additional issues. But issues are on,
ಮಾಡಿರ್ತಾರ ಮೋಸ್ಟ್ಲಿ.
ಮಾಡಿಲ್ಲ.
ಜಜ್ಮೆಂಟ್ ನಾಗ ಇರತ್ ನೋಡಿ.
Page 40.
The additional issue was page 41. But page 40, my lord, issues. 3 issues had been framed. That was on 5/12/2005. But the amendment came to be allowed
Page 41 you will find.
41, your lordship will find additional issue.
41. ಇಲ್ಲ, ಇಲ್ಲ. 41 is 40 is additional written
41,
statement.
issue 40, 41. Lordship is looking into 684, no?
885.
680. 684 only relates to this OS number 3230. Just I'm only narrating the
Additional
facts,
issue.
how in the first suit, my lord, the
Ah,
reliefs were set on what basis? Issue- my lord, page 40, the issues, my lord, that is. that is the
additional issue
plaintiff
was in respect of that amended prayer.
amendment, but my lord, earlier issues only in relation to the prayer on the basis of the pleadings. Issues are always framed, my lord, only on the
Pleadings.
basis of the pleadings of both the parties. Page 14 will note, whether the plaintiff proves that he is in lawful possession of the suit scheduled property, because that is the prayer, that is the pleadings. Then whether the plaintiff further proves that the defendants are interfering with his possession of the suit scheduled property, then my lord, whether the plaintiff is entitled to the injunction.
They filed appeal. Appeal ನಲ್ಲಿ ಇವ್ರು ಏನಂತ ಕೇಳ್ಕೊಡ್ತಾರೆ, ನಾವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ವಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ಔಟ್ಕಮ್ ಆಫ್ ದ ಸೂಟ್ ಅಂತ ಮಾಡ್ಯಾರ ಅಫಿಡವಿಟ್ ಇದೆ. ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಟ್ ಅಫಿಡವಿಟ್ ಅಪ್ಲಿಕೇಶನ್ ಈಸ್ ಫೈಲ್ಡ್. ಅದೇ ಸಲುವಾಗಿ ಅದೇನು ಲೇಟ್ ಅಂತ ಹೇಳಕ್ in terms of his own undertaking, this additional issue is there. ಅಲ್ಲಿ ಏನಾಗಿದೆ, he had filed application under 3912.
What?
That was rejected. Against that, he filed MA.
MFA.
MA also went against him. Then he filed MFA.
Yes.
ಆ MFA ದಲ್ಲಿ ನೀವು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ತೀರಿ ಏನಂತ, ನಾವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತೀವಿ, that will be subject to the outcome of the suit ಅಂತ. ಆ ಕಾರಣಕ್ಕೆ MFA ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ಆದ್ಮೇಲೆ ನಿಮ್ಮ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಫಿಡವಿಟ್ ಇರುತ್ತಲ್ಲ, ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ ದಟ್ this application for amendment of the plaintiff ಹಾಕ್ಬಿಟ್ಟಾರೆ.
Remember, the entire suit pleadings is that my lord, the plaintiff is in peaceful possession and enjoyment.
Correct.
Assuming that my lord, that undertaking is given before the Honorable Court in MFA, that we are putting up a construction. So the plaintiff, my lord, admits that he is not in possession and the referent is in possession. That is the point I am driving. Just because, my lord, in the context of that undertaking, if he is seeking for amendment, prayer AA, my lord, then the
See the application and affidavit. All right.
my submission is, my lord, the entire my lord, suit claim goes. Then where the suit survives, my lords, if he is admitting that the defendants are in possession and they have put up construction or they are proceeding with the construction, and in relation to that he seeks for a prayer amendment which is allowed,
For demolition and possession.
demolition and possession, that my lord, the entire basis for the suit, my lord, goes.
How?
Suit does not, because his entire pleadings is, my lord, he is in peaceful possession and enjoyment.
Suppose I give my property to you,
Please.
I put you in peaceful possession. You start erecting Taj Mahal there. Am I not entitled to say you are not supposed to put up construction?
No.
I am.
My lord, the here, my lord, suit is always valued, my lord, on the basis of the prayers. Just for, my lord, for seeking a an order of permanent injunction, what is the court fee paid? But court fee paid is only under
Subject to
police.
correct- Declaration is there. Connected suit is
Connected
one for
suit, I'll-
declaration.
Correct,
Suit-
then.
The suit property is 1409(A) in your injunction suit, which is also the suit property in the declaration suit. Which has been.
Declaration
So,
suit, where,
so finally, the substratum of the matter will be if you
Title.
address
No,
the.
as
type
far
of
as this
declaration,
suit claim is
all this
concerned,
becomes
no, no,
consequent.
my lord.
Correct.
Then as per this suit, my lord, if your lordship,
No,
my lord,
ultimately.
accepts my submission that, my lord, the very suit, my lord, becomes infructuous rather. It goes. My lord,
Have you taken
entire
up-
pleading,
Alright. Have you taken up that contention in your WS?
the appeal, my lords.
Yes. Sure.
RFP. Lordship, wants me to show in the written statement or in the appeal?
ಅಲ್ಲ that state ಅದನ್ನ ತಗೋಬೇಕಲ್ಲ. ಅದಕ್ಕೊಂದು WS ನಲ್ಲಿ ಅದನ್ನ ಸ್ಟ್ಯಾಂಡ್ ತಗೋಬೇಕು. ಅದ್ರ ಮೇಲೆ ಒಂದು ಇಶ್ಯೂ ಫ್ರೇಮ್ ಆಗ್ಬೇಕು.
Please.
Suppose if they do not frame, you should make application under order 14 rule 5, seeking framing of additional issue. Then ಈ ಪ್ರಶ್ನೆ ಎಲ್ಲ ಬರ್ತದೆ. ಅದ್ರ ಬದ್ಲಿ, as my brother suggested, title ಮೇಲೆ ಬನ್ನಿ. Come to the title ಮೇಲೆ ಏನಿದೆ
Then
material,
we will.
what are the issues and what is the material ಅಷ್ಟೇ.
As well, these are the facts about the case. Now, let us see, Melody, immediately after 1 year, even before this amendment came into this suit, 30 to 35, another suit is filed, as his lordship put it, that is for declaration. Let us see what is the,
ಅದನ್ನೇ ನೋಡಿಕೊಳ್ಳಿ.
that you.
Sequential ಆಗಿ ಹೋಗು.
But this suit is filed
5253. ಕರೆಕ್ಟಾ?
15255.
Huh?
15253.
15,525.
15253. 15253. Arising, relating to RFP number 885.
885.
Filed on,
ಹಾ.
this suit is filed on
ಇನ್ನೊಂದು suit ಇದೆ. ಅದನ್ನ. Okay, 152 ಅದು. All right. Okay, ಕಡಿಮೆ ಇರ್ತದೆ ಅಂತ. ಅಲ್ಲಿಂದ ಕಂಟಿನ್ಯೂ ಆಯ್ತು. Okay. Yes.
This suit, 15/253 of 2005
Ah.
is filed on 28/1/2005.
By 6 persons.
28th January 2005.
By 6.
By 6 persons. That is why first, I.
Correct.
But
Suit property ಏನದು?
by 6 persons.
Property ಏನು?
Property, same property.
ಏನದು?
Property number, in the earlier suit itself, just
ಏನೋ ಅದು ಲ್ಯಾಂಡ್, ಸೈಟ್, ಬಿಲ್ಡಿಂಗ್.
property is
Page number 14 of the plain paper book.
here, my lords.
3 schedules.
A schedule property, page 14. That suit relates to only 1409A. Here, my lord, very cleverly they say like this, all that piece and parcel of the site bearing number 1409A overwritten as number 1928/CMC Kata, situated at 14th Cross Judicial Layout, Allalasandra Village, Yelahanka Hobli, Bangalore.
Yes.
Then B schedule is all that piece and parcel of the site bearing eastern portion of site number 1928F. Because, but in the meanwhile, my lord, this gift deeds, 2 gift deeds. Please. That plain. Suit schedule. Wrongly claimed.
Part of this property is western portion is eastern.
ಎರಡೂ ಸೇರ್ಬಿಟ್ಟು ಇದಾಗಿದೆ. ಓಕೆ. ಹಾ.
ಇದರಲ್ಲಿ very prayers in both the suits and scheduled properties stated mentioned in the both the suits are very important. In this suit, subsequent to filed on 28/1/2005, this is the schedule A schedule. All that piece and parcel of the site bearing number 1409A mentioned overwritten as number 1928 CMC Kata situated at 14th Cross, Judicial Layout, Allasandra Village, Yelahanka Hobli.
ಜುಡಿಷಿಯಲ್ ಲೇಔಟ್ ಸೇಮ್ ಇದೆ. ಜುಡಿಷಿಯಲ್ ಲೇಔಟ್ ಸೇಮ್ ಇದೆ.
ಜುಡಿಷಿಯಲ್ ಲೇಔಟ್ ಇದು ಅಲ್ಲಾಳಸಂದ್ರದ್ದೇ.
ಅದ್ರ ನಂತರ ವೇರಿಯೇಷನ್ ಏನ್ ಬರ್ತದೆ?
ವೇರಿಯೇಷನ್ ಇದು ನೋಡಿ, ಈಸ್ಟ್ ಟು ವೆಸ್ಟ್ 125 feet and north to south 175 feet ಅಂತ A schedule property. Then B schedule and C schedule melod, the correct melod mention all that piece and parcel of the site bearing eastern portion of site number 1928F, Yelahanka Municipal Corporation, Kata number 1934. Kata number 1934, situated Judicial Layout, Allasandra Village, ಇಲ್ಲಿ 14th ಕ್ರಾಸ್ ಇವೆಲ್ಲ ಹೊಟ್ಟೋಯ್ತು. ಯಲಹಂಕ ಹೋಬಳಿ
ಆ ರೀತಿ ಆಗಿದೆ.
ಈಸ್ಟ್ ವೆಸ್ಟ್
B plus
100
C
feet
is equal to A. Yes.
and north to south 125 feet. But the area measures is 175 by 125 feet. B schedule describes 100 by 125 because one gift deed was executed by one of the appellants at the difference Gopi in favor of his wives, two wives, Lakshmi Devi, and this is executed in another C schedule property that would measure 1928/1, new number 1928F1. One 1928F original number, another is 1928F1 Yelahanka city. Judicial Layout measuring east to west 75 by 125 feet. That is correct because as per the gift deeds in 2002, Gopi Millard, one of the defendants or appellant number 3, had executed 2 gift deeds dividing
A.
property number 1928.
That is no.
But
Dividing
290
property number 1409/A.
No,
No.
we are not concerned with that at all. But all that defendants appellants are the owners of.
Property will remain.
ಇಲ್ಲ just suit prayers ಓದ್ಬಿಟ್ಟು then I will explain to you how we are.
ಕೊಡ್ತಾರೆ ಇನ್ನೊಂದು ಖಾನೇಶು ಮಾಡಿ ಬರ್ತದೆ. ಇಶ್ಯೂ ಹೋಗಿ ಎನಿ ಐಡೆಂಟಿಟಿ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಇಶ್ಯೂ ಇದೆಯಾ?
ಇಲ್ಲ. Issues melody your lordship will get at page 55. Whether the plaintiffs prove that they are the owners of the property bearing number 98/7 ಅಂತ ಇದೆ. ಇಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ ಅವ್ರು ಕ್ಲೈಮ್ ಮಾಡೋದು 1409A. ಇಲ್ಲಿ ಫಸ್ಟ್ ಇಶ್ಯೂ ಈಸ್ bearing number 98/7 ಅಂತ. ಸರ್ವೆ ನಂಬರ್ 98/7 ಅದು their claim as per the pleadings. Allasandra Village, Yelahanka Hobli, Bangalore. Whether plaintiffs prove that schedule A property came to be allotted and handed over to them by virtue of compromise decree. The compromise decree, that is compromise between the plaintiffs and the society, that we will come. Whether the defendants prove that schedule A property allotted to the society as alternate site for using different number 3's property for the purpose of road. This we are only concerned with this. Whether the plaintiffs prove that defendant number 3 has no title over schedule A property to give the schedule B and C properties to first and second defendants. Correct. That. Whether the plaintiffs are entitled for the relief of declaration as sought for. Whether the plaintiffs are entitled for the relief of permanent injunction as sought for, to what order. That these are the, as far as the identity of the property, pleadings are very clear. We have very categorically stated, defendants have very categorically stated that we are nothing to do with the so-called number, property number described by the plaintiffs as 1409/A.
That is A,
40,
Schedule
14
A,
not 9 A.
Schedule A.
A.
Ah.
Schedule A either, that is their claim, even in the other suit, that is 1409, A. There in there, my lord, in the other suit, how the property is described, just for a moment, your lordship will say, ಇಲ್ಲಿ ಓವರ್ ರಿಟರ್ನ್ ಅಂದ್ರು, ಅಲ್ಲಿ 32-35 OS ನಲ್ಲಿ filed by M. Nagaraj, this is the how he has described. All that piece and parcel of vacant site bearing number 1409A. That is their claim. 1409A, they claim that they are the owners, absolute owners, having been granted by the society in the compromise decree. Bracket nalli wrongly claimed as site number 1928. F in the layout formed by the judicial society out of the lands.
ಅಲ್ಲಿ ಐಡೆಂಟಿಟಿ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿ
ಇಲ್ಲ,
issue ಎಲ್ಲಿದೆ?
ಇಲ್ಲ.
ನೀವು
Identity-
ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿರಾ? ಇವ್ರು ಕೇಳ್ತಾ ಇರೋ ಪ್ರಾಪರ್ಟಿ ಬೇರೆ, ಈ ಪ್ರಾಪರ್ಟಿನ ಬೇರೆ.
that is the case of the
ಎಲ್ಲಿದೆ?
defendants. Defendants written statement ನಲ್ಲಿ,
ತೋರಿಸಿ.
even in that suit also 32-35 also my lord, written statement I will not.
ಇದರಲ್ಲಿ WS ಹಾಕಿ.
ಇದರಲ್ಲಿ my lord, para 2 it's 16, 17 ನಲ್ಲಿ ಹೋಗಿ. Existence ಇದರಲ್ಲಿ whole case of the difference is ಈ property number 1409A ಅಂತ what the plaintiffs claim is a fictitious number. There is no
Such
such
property at all.
property at all in the society's layout. Society, my lord, must be able to demonstrate this according to the pleadings. This 1409 bar A is formed out of survey number 104. My lord, in the compromise decree, I will later, my lord, I will
But
take your
society is
lordship.
not a party to the suit.
No, for the
ಮತ್ತೆ ಅವ್ರ
compromise.
ಮೇಲೆ ಏನ್ ಬರುತ್ತೆ?
ಇಲ್ಲ.
They are not parties at all.
They are not the society party ಇಲ್ಲ. ಅದರಲ್ಲೂ
Did you take any contention that society is a necessary party? Without that, we cannot decide proper party. ಅದೇನ್ರ ತಗೊಂಡ್ರಾ?
This is, this is how we have put in, come to para 16 in the para 2 in this particular case, lordship got
ಹಾ,
para 2 in the last sentence.
para 2.
Para 2 ನಲ್ಲಿ the plaintiffs in fact cannot maintain such a suit unless they traces their rights to any existing declaration in respect of their property. Therefore, before the plaintiff seeking prayer in respect of the defendant property, this itself shows that they are different. He must prove the existence of their property. Property ne illadu. In this particular case, the plaintiff alleged property bearing site number 1409A itself is not existing in the locality.
Identity of the property issue. He's saying it's a non-existent property. That is so. One issue should have been framed with the suit property. Has correct. ಮಾಡ್ಕೊಂಡು ಆ ರೀತಿ ಮಾಡ್ತಾರೆ. ಅದು ಟ್ರೇಸ್ ಮಾಡಿ ಆ ಐಡೆಂಟಿಟಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿ. ಬಟ್ ಸೊಸೈಟಿ ಕಡೆಯಿಂದ ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರು?
Society. No one, but I'm instructed, no one was examined on by the society. Well, in the index itself, we have said,
After society.
Nagaraj was examined, the other suit 30 to 31.
First take, yes. Okay. Right.
ಇದರಲ್ಲಿ ಅದರಲ್ಲಿ ಆ ಸೂಟ್ ಎಷ್ಟು page?
More plausible.
ಇದರಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅದರಲ್ಲಿ ನಾವು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
Itself just like this. I'll come to 146.
That is the compromise.
Para 2,
Para two,
last
yeah,
about 7 lines.
the suit was filed by the society.
Wait a minute. Para 2, page 146, para 2, from bottom, read 6 lines, 7 lines.
But just I want to draw your lordship.
No, we'll come to that. We are saying something in your favor.
That's what,
ಹಾ,
ಆಮೇಲೆ
ಅವಾಗರ ಓದ್ಬೇಕಲ್ಲ.
parties ಯಾರು ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. We are not parties.
ಆಯ್ತು, ನಾವು
Correct.
ಅದನ್ನ
Please,
ಹತ್ರನೇ
go
ಇಲ್ಲಿ
please.
travel ಆಗೇವಿ.
Correct. 2, in pursuance of the said agreement of sale of the scheduled land and the plaintiff being put in possession of the same, formed layout in the scheduled land along with other lands which were acquired by means of acquisition proceedings under the Land Acquisition Act. The plaintiff developed the entire land, making roads, underground sewage, water supply, and electricity, and formed sites, giving site numbers of all the lands, including acquired lands by the plaintiff society. The identity of the scheduled land at present cannot be traced. I am
That's what we
grateful to your
wanted to
lordship.
tell you.
Traced, and but only sites with numbers could be traced. So as on the date, even they allotted this site, particularly 4 sites were allotted as per this compromise, their favor, including 1409A. The kata of the sites have been made with the Yelahanka municipality and assessed to tax. So society makes a statement in this compromise petition that in respect of all the sites formed by the society in the air layout, municipal numbers have been given. Kata is also made. That should be the name of the society, municipal kata. This is what. The kata of the sites have been made with the Yelahanka municipality and assessed for tax. The plaintiff society has allotted sites to its members and executed sale deeds in their favor, including the sites formed in the scheduled land. Then for 7 minutes, the affidavit at page 148. But para 6 also important because how defendants, what are their terms, my lord, to enter the compromise. They made a statement, they have withdrawn all their pending suits. We do not know how many suits were pending between the society and these plaintiffs. Then 7, plaintiff has agreed that out of the sites formed in the layout, including the scheduled land, that site number 1861, 1671, then 1672, and they had mentioned earlier some number they have struck off, and site number 1409A, the area of the land measuring 125 by 175 as per the schedule mentioned below, schedule below, with the site numbers, measurement and boundaries as mentioned below, in the table being given and allotted in favor of the second defendant and his sons defendants 3 to 7 shall be the owner in possession of these sites, in respect of which the plaintiff society has no right, title or interest thereof. 1, 2, 3, 1861, 1671, measurements all 14 by 49 by 49, 40 by 40, 40 by 40. 4 and 5 minutes, some continuous site numbers are mentioned before their
This is this compromise decree. Parties are the housing society
and the plaintiffs.
and the plaintiffs in the suit. Correct.
Please. Formed out of serial number 4 ಅಂತಿದೆ ನೋಡಿ.
I agree that out of the sites found, the therefore layout including scheduled land. The area of land measuring 125 to 175 are the schedule mentioned below with numbers measuring. Boundary mentioned below in favor of the second defendant. Defendants in the compromise decree. How and the suit is being contested. How and the suit is being contested. There of its member is working.
You find it anywhere else they put in the even since our readings ಅಲ್ಲಿ out of 7 and 4 ಅಂತ.
So it's fine. Our society and the owner of this sense of property ಏನಿದೆ ಅದರಿಂದ ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ನಿಮ್ಗೆ ಈ ಸೈಟ್ ಸೊಸೈಟಿನ ಅಲಾಟ್ ಮಾಡಿತ್ತು.
Society allotted.
ಅದು ನಿಮ್ಮ
But
readings
what they had done is, the society, my lord, in addition to the lands acquired under the Land Acquisition Act, or my lord, they had also started, my lord, utilizing the lands surrounding.
How you got title to the property? Just
1920. 1928. 1928. Blood, while forming the layout, sites were all made, layout was formed. They had no access road at all. Layout ಮಾಡದ್ ಮಾಡ್ಬಿಟ್ರು. ಅಲ್ಲಿಗೆ ಹೋಗಕ್ಕೆ access ಇಲ್ಲ. They started forming the road in survey number 98/3 belonging to the defendants. 98/7. Otherly. Then my lord, the dispute arose. Then they stopped the formation of the road. Then my lord, we had a compromise. In lieu of that, my lord, the area that they had utilized for the purpose of formation of the road in our land, they, society, my lord, allotted this site number, which came to be numbered by CMC, my lord, later. Even then, my lord, they did not have the number, even when they granted. They have given us 170/125. That is how, my lords, after, my lord, we are put in possession.
The plaintiffs also claim through that site.
Very
allotted
same
by
society.
No. Let them show, my lord, any document they site number 1409A exists in the layout of the society, or when under this compromise they are put in possession ಅಂತ ಹೇಳ್ತಾರೆ.
ನಿಮ್ಗೆ ಹೆಂಗ್ ಬಂದ್ 1409
1409, we are nothing to, we are not claiming 1409 at all.
not claim at all.
We are no way. They are,
But description of the property, the factor.
ಈ 40-60 allot ಮಾಡಿದ್ದು 1861, 1670, these three sites are all in the somewhere in the land. ಅದು 98/7 ಅಲ್ಲಿ ಫಾರಂ ಮಾಡಿರ ಅದರಲ್ಲಿ. That your lordships will get in para 8. This 1409A, if they have to give 1409A, there must be site number 1409 somewhere in the within their layout. Let them show. ಇಲ್ಲ ಸುಮ್ಮನೆ ಇಲ್ಲಿ ಇದು ಕಣ್ಣೋರ್ಸೋದು ಸೊಸೈಟಿ has virtually fooled these plaintiffs. ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಟ್ರು ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಯಾವುದೋ ಒಂದು ನಂಬರ್ ಎ ಅಂತ ಕೊಟ್ಕೊಳ್ಳೋಣ, ಅಡಿಷನಲ್ ಕೊಡೋದೆಲ್ಲಾನು A, B, C ಏನೋ ತಗೊಳ್ಳಿ, ಇರ್ಲಿ ಇಲ್ದೇ ಇರ್ಲಿ ಒಂದು ನಂಬರ್ ಕೊಟ್ಟು ಮಾಡೋದು.
ಲೇಔಟ್ ಪ್ಲಾನ್ ಪ್ರೊಡ್ಯೂಸ್ ಆಗಿದೆ ಏನು?
ಲೇಔಟ್ ಪ್ಲಾನ್ ಮೇಲೆ
ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್ ಪ್ಲಾನ್ ಪ್ರೊಡ್ಯೂಸ್ ಆಗಿದೆಯಾ? ಮಾಡಿಲ್ಲ.
Approved layout plan produce ಆಗಿದೆ. PD official examine ಆಗಿದೆ.
ಎಕ್ಸಿಬಿಟ್ ಏನದು?
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ PD ಅವರು ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಸಿವಿಕ್ ಕಮಿಟಿ ಸೈಟ್ ಸರಿಯಾಗಿ
Exhibit. We are asking a question to you. Answer the question. What is that exhibit? Layout plan, the exhibit ಏನು?
let them show from the approved plan. He talks of BDA.
That's what.
There must be approved plan.
155.
Page number 155 of the paper book, not in RFA 885 of 2019. 155.
ನಾಟ್ 5 ಎಲ್ಲಿದೆ ಇದರಲ್ಲಿ?
First of all, ಇದು approved plan ಅಲ್ಲ.
ಅಲ್ಲ ಯಾಕೆ ನೀವು
ತೋರಿಸಲಿ ಎಲ್ಲಿದೆ ತೋರಿಸಲಿ 14.
161ನೇ ಪೇಜ್ ಅಲ್ಲಿ 161.
ಎಲ್ಲಿದೆ?
Your lords may kindly refer to this portion.
1928 ಎಲ್ಲಿದೆ?
ಏನ್ 1920?
ನಮ್ದೆ 192
ಅಲ್ಲಲ್ವಾ? ತೋರಿಸಲಿ.
161
ಎಲ್ಲಿ?
161 ಪೇಜ್ ನಂಬರ್ 161.
ಅದು ಎಲ್ಲಿದೆ ಬೋರ್ಡ್?
405 ಇದ್ದಂಗೆ ಇದೆ.
104 ಅಂತ ಇದೆ.
He is here.
Plus
ಅಲ್ಲೇ ಬರೀತೆ.
ಇಲ್ಲಿ ಇದ್ರದ್ದು ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಒಟ್ಟು ಗೊತ್ತಾಗುತ್ತೆ. 160. East by road. It's road. The road. East by road,
CMC.
west by water channel. Then go on. There's another side. Even side on the side here. Brother, Mr. Reddy, please kindly come to 161. Please, put your finger on 1409A, please. Now, on the right hand side
Please, ma'am.
is the east. It has to be, please. East right, road, road. Come to page 14. 14, yeah. See the description.
East by road is,
Road. Come to left, west.
please, ma'am.
Where is the water channel? Left, there is a site. Please. Come to north. Please. Property belonging to third defendant bearing site number 1928. Show 1928. Schedule. We are reading the location of the site as appearing from the approved plan which you have produced.
And on top, your lordships can see 1928
1928.
on top, which is
Where?
showing survey number 98/1. Next to that, your lordship, on the left-hand side, 1930, 1939, 1930, 1929, 1928. Same page. Well, as far as the identification of the property is concerned, I had filed an execution petition for execution of the sale deed through court.
No, that cannot be 1928 at all. Road ಆದ್ಮೇಲೆ ಇರ್ತದೆ. In the very approved layout, there is a road. It appears to be 40-60 road. ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಇದು ಏನು ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ.
Not in the execution proceedings, my lord, when I filed an execution petition to get the sale deed through court.
To execute the
The sale deed compromise decree, these very
There is the
appellants.
question of execution.
So these,
You have said you have put in possession of the property.
but sale deed is not executed.
Huh?
Sale deed was not executed.
Your execution was for sale deed or execution for delivery?
Execution of sale deed,
Only sale deed,
only sale deed.
not for delivery.
These very appellants filed an obstruction application. Evidence was recorded for about 7 years in the execution proceedings. Execution proceedings, there was inquiry done. And
Budget order 21 rule 97.
97. And this particular execution petition, they wanted to get dismissed by filing order 21 rule 97. After inquiry, it was dismissed and court executed sale deed through court. When the sale deed was taken to the sub-registrar for registration, sub-registrar found that the property is fully developed. Therefore, they want to inspect and charge the present stamp duty. District registrar visited along with the photographs.
Where is that 2197 order? No, 2197 is rejected.
Rejected. and
Rejected
they
after
came up-
trial,
they come
obstructors
up-
application.
They come up in appeal before this honorable court and they file a memo for withdrawal of the RFA.
With liberty.
There is no liberty as such.
Where is that 2197 order? Page 830.
Exhibit B 72, my lord.
Page number?
That your lordship can find from page number 779.
Volume 2, please.
79.
80, 80.
ಹೌದು. 7, 4 ಅಂತ ಹೇಳ್ಬೇಕಿತ್ತು. ಹಿಂಗಿದ್ದಾಗ ಅಥವಾ ಹಿಂಗ್ ಸಲಲ್ಲ. ಈ ಕಡೆ ಇದೆ. ಒಂದು ಸೆಕೆಂಡ್ಲಿ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿಯಲ್ಲೇ ಡೌಟ್ ಇದೆ. ಹಾ, ಅವಾಗ ಪ್ರಶ್ನೆ ಮುಗಿದೆ. ಇಟ್ ಬಿಕಮ್ಸ್ ಎ ಡಿಗ್ರಿ. ಡಿಗ್ರಿ ಆಗುತ್ತೆ. ಗೊತ್ತಿಲ್ವಾ? ಟೈಪಿಸ್ಟ್ ಕೊಡಿ. ಅಲ್ಲಿ it is not treated that ordinarily in Paramount Industries, ILR 92 Karnataka. Paramount Industry Justice Swami say an order made under Order 21 Rule 97 partakes the character of a decree under Rule 103 or 104, I don't remember, 292, very long ago. Provided finality characters are present in the order. If the order lacks the finality characters, then it is a decree, but they are entitled to relitigate. Kindly come to 785. That liberty is reserved by the court itself. By the court say he should litigate elsewhere. There is no harm will be presented because to the objector, and she can establish her case by the evidence adduced from both places.
Last.
Difference also. Can. Perhaps our date here suit was pending. Therefore, they said like that. As on that date, as on the date 2197 order is made, the suits were pending at large. That's the reason they said like that.
2002 is the year in which execution proceedings came to.
Date of order,
Order
2009.
2009.
14th August.
Therefore, both you can lead evidence and come to a conclusion. I will reject it by that. No prejudice will be cast upon. On rightly wrongly, some order is made. And rightly wrongly, the coordinate bench perhaps upheld that order also. Love that single judge perhaps. There is no consideration at all. The objector filed with the date is a content for fiction side say disputed property. Like this, nobody's case, no such constructions are there in the social property. The thing himself has admitted the objector has put up certain constructions in the disputed property. The question of appointing court commissioner inspections to find out this building does not arise. But in the case of the objectors that is not at all in existence. Spot. He is claiming property.
Para 8.
But the court commissioner, even if appointed, cannot say whether there is a property is there in site number so and so or site number so and so. Even that court is under confusion. That the sale has to be resolved with
Yeah, that's what I-
appreciating the
788.
from both sides. Thus viewed from any angle, the application for appointment of court commissioner is divided. Further, consideration penalty. Penalty Is to depend, there is no consideration. ಇಲ್ಲಿ ಒಂದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
Please.
Justice Ullal and another judge. How orders under 2197 should be understood?
Please.
When that order is not made after holding trial, though it may partake the character of a decree in under Rule 20, Order 40, 21, Rule 103, because of Paramount Industries, ILR 92 Karnataka, perhaps
Will be.
92, 91 Karnataka, 254. ಇದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಬರ್ಬೇಕು. Justice Swami's judgment, one of the best judgments that we were taught.
Pages two. Pages
ILR 1991 Karnataka, 254, Paramount Industries versus so and so. La? Huh? CM Maliga.
Please.
Illi, this order appears to be a matter for your appeal task. This order is made because suits were pending, where both the parties can lead evidence in abundance, and court will decide that one. Therefore, obstructor's application is rejected. And that has been upheld by the High Court because observations are made that way. Even their identity of the property is again put in lurch because court observes that way.
Para-7 court commissioner was not able to.
And your compromise decree term itself says we are not sure of the location.
Not the compromise petition, not, there are two schedules. A schedule is my property. B schedule is the property, the alternative sites which have been given to me.
But he is not a party to your compromise decree.
Not
A
your-
compromise
your
decree is only a contract with a seal of the court superadded. Therefore, you have to interpret it with the doctrine of privity. That does not bind him at all.
Lord, what I'm trying to submit before the court is, as your lordship pointed out, paragraph number 2, and said there is no proper identification. The particular paragraph not refers to my land because compromise petition is drafted in such a way that even though I am owner of the land, now I am not able to identify where exactly it is because layout is formed. Therefore, instead of giving me compensation, they have given me alternative sites.
No, that question arises if identity is established.
Lord,
Identity establishment, that will be begging the question.
For a moment, my lord, your lordships may kindly see, in the first instance,
Anyway, that we have given a piece of our mind,
please,
so that you will come out with your answer.
please.
That's all, nothing beyond that. We have given the rulings also. You ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
Please. Next week. Next week. Anyway.
ಅದು ಆ ಜಡ್ಜ್ಮೆಂಟ್
Please.
Justice Ullal and another bench, another judge,
Will be.
they consider the finality of the decree under Order 21, Rule 40-27, read with 103. When final, because 103 has a different, CPC, 103, 103 or 104. There is
103.
some, if the suit is pending, is one aspect.
Please.
If the suit is contemplated, is another aspect.
Please.
Let us see that.
And one question to be.
103,
determined.
kindly read 103, then come to 104.
Please.
Orders to be treated as decrees, where any application has been adjudicated upon under Rule 98 or Rule 100, the order made thereon shall have the same force and be subject to the same conditions as to an appeal or otherwise, as
fit.
if it were a decree. Kindly come to 104. Every order made under not 101 or 103, this is 9800 excluded. That, see that, shall be subject to the result of any suit that may be pending. This is interpreted by Justice Ullal, Honorable Justice Ullal, and another, I do not remember the bench partner. But they have beautifully considered,
Please.
after referring to Madras High Court judgment by Justice Rajamannar.
Please.
One of the great judges of Madras High Court. His views have animated that decision.
Please, my lord.
Bring that judgment.
Complete.
Third submissions of learned senior counsels, save that for the appellant's part for further submission on behalf of the appellant. Relist on, relist when the bench.
Please, my
In
lord.
order, last time.
Date,
Well, how can we do it? Very difficult.
next
We have
week,
to see. No, that, we'll.
because continuity could be there. Next
Correct,
week,
correct.
Friday.
To, bench has to.
Friday. Because even Saturday is sitting day, next week.
Next Saturday also.
Saturday also, first is.
You want, it appears you have determined to finish off the judges. Some liars also.
20.
Next Saturday. Next Saturday.
Very good.
Will it be all right, sir? For you also?
Saturday.
ಇನ್ನೊಂದಿದೆ. Okay. 2:30 ಅಂತ ಹೇಳ್ಬಿಡ್ಬೋದಾ?
2:30 ಅಂತ ಹೇಳಿ ಮಾರ್ನಿಂಗ್
ಸುಮ್ಮನೆ ಅನ್ನೆಸರಿ ಕಾಯ್ಕೊತ್ ಕೊಡೋದು ಉಳಿತದೆ. Morning you can have your morning
good.
work and come back.
2:30. Upgrade. ನಾವಾ? IL 1990. ರಾಜಾ, ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ರಿ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದು. ಸಾಹೇಬ್ರಿಗೆ ಜಡ್ಜ್ಮೆಂಟ್
ಜಡ್ಜ್ಮೆಂಟ್ ಅದು.
IL 1991.
ಎರಡು ಹೇಳಿದ್ರಲ್ಲ, ಎರಡು ಇದೆ.
ನೋಡೋಣ, ಹುಡುಕನ ಬಿಡಿ, ಸಿಗುತ್ತೆ ಡೈಜೆಸ್ಟ್. ನಮಗೂ ಸ್ವಲ್ಪ ಕೆಲಸ ಬೇಕಲ್ಲ, ಅದು ಕೊಟ್ಬಿಡಿ. ಕೊಡಿ, ನಿಮಗೆ ಸಿಕ್ಕಿರಿ ನೀವು ಕೊಡಿ, ನನಗೆ ಮುಂಚೆ ಸಿಕ್ಕಿ ನಾನು ನಿಮಗೆ ಕೊಡಿ.
ಇದು ನಮ್ದನ ಯಾವಾಗ ನೆಕ್ಸ್ಟ್ ಕ್ಲಾಸ್ ಅದ 1ನೇ ತಾರೀಕು. ಮೂವತ್ತೊಂದು ಒಂದು ತಾನೆ, ಈಗ ನಾಳೆ 25.
ಸರ್ ಈಗ ಸಾಹೇಬ್ರು ಸಿಂಗಲ್ ಇದ್ದಾರೆ ಈಗ ಅದಾದ್ಮೇಲೆ
ಇದು ತಾವು
Ready ಇದೆ.
ಇದರಲ್ಲಿ ಸಬ್ಮಿಷನ್ ನೋಟ್ ಅಲಾಂಗ್ ವಿತ್ ಅನಕ್ಷರ್ಸ್ ಸೀಲ್ಡ್ ಕವರ್ ಅಂತಲ್ಲ ಇದೆ ಅದು ಸೀಲ್ಡ್ ಕವರ್
ಸ್ಟೆಪ್ಗಳು ಅಂತ ಬೇರೆ ಹೇಳ್ತಾರೆ.
ಸಬ್ಮಿಷನ್ ನೋಟ್ ಅಲಾಂಗ್ ವಿತ್ ಅನಕ್ಷರ್ಸ್ ಸೀಲ್ಡ್ ಕವರ್ ಸಬ್ಮಿಟೆಡ್ ಬೈ ಎನರ್ಜಿ ಆಫ್ ದಿಸ್ ಆಫೀಸ್ ಸ್ಟೆಪ್ಗಳು.
ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದಾರೆ ಏನೋ ಗೊತ್ತಿಲ್ಲ. ಫೈಲ್ ಜೊತೆ ಸಬ್ಮಿಷನ್ ನೋಟ್ ಅಂತೆ. ಸಬ್ಮಿಷನ್ ನೋಟು
ಇದೆ. ಮತ್ತೆ ಇದೆ. ಇದಾ
ಇಲ್ಲಿದೆ ನೋಡಿ.
ಸಬ್ಮಿಷನ್ ಅದ್ರ ಇಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಯಾವ
ಓಪನ್ ಮಾಡಿದ್ದಾರೆ, ಮಾಡ್ಬಿಟ್ಟು ತಿರ್ಗಾ ಹಂಗೆ ಇಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಇಲ್ಲ ಸೀನ್ ಮಾಡಿದೆ ಅರ್ಧಾಗಿದೆ.
ಅದಕ್ಕೆ ಇದರಲ್ಲಿ ಕೆಳಗಿತ್ತ ಇಲ್ವಾ?
ಬಿ ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ಲ ಓಪನ್ ಇರಲ್ಲ. ಎರಡೇ ಬಿ ಫೈಲ್ ಇದೆ.
ಬೇಡ ಬೇಡ ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಬನ್ನಿ ಮೇಡಮ್, ಅಲ್ಲೇ ಇಲ್ಲ ಬರೋರು ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ನೀವು ಒಂದ್ ಮ್ಯಾಟ್ರ್ ಅಲ್ವಾ, ಅರ್ಜೆ ಮಾಡ
ಮತ್ತೆ ಸಿಂಗಲ್.
ಹಾ ನೀವು ಎರಡು ಮ್ಯಾಟ್ರ್ ಬರೀ ಎಷ್ಟು ಅರ್ಜೆಂಟ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ, ಏನಿಲ್ಲ. ಏನ್ ನ್ಯೂಸ್? ನೆಕ್ಸ್ಟ್ ಸಾಟರ್ಡೆ ನೋಡಿ ಮೇಡಮ್, ಬೆಂಚ್ ಇರ್ಬೋದು ಮೋಸ್ಟ್ಲಿ.
ಹೌದು ಹೇಳಿದ್ರಲ್ಲ.
ಇದು ಹೇಳಿದ್ರೆ 2:30 ಅಂತ ಅಪ್ಡೇಟ್ ಬರ್ತಿಲ್ಲ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಂತ. ಅವಾಗ ನೀವು ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಹೋಗಿ ಸೆಟ್. Matter pertaining to Dharwad bench. Number 1 for further hearing, Ravi S. Balikai, Chandrasekhar P. Patil.
ಕನೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ. ಒಂದು ಯಾವ್ದಾದ್ರು ಬೇರೆ ಡೇಟ್ ಹಾಕ್ಬಿಡಿ. ಫರ್ದರ್ ಹೆಂಗೆ ಬೇರೆ ಒಂದು ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಹಾಕಿ, ಅದೆಲ್ಲ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಹಿಂಗಾಗಿ ಡಿವೋರ್ಸ್ ಮ್ಯಾಟರ್ ಅವ್ರ ಅವಸರ ಮಾಡ್ದಂಗೆ ರಿಲೀಸ್ ಮಾಡಕ್ ಬರಲ್ಲ. ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟ್ ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟ್ ಧಾರವಾಡ.
ಮುಂದೆ ಹೋಗ್ತದೆ.
ಮೇಡಮ್ಗೂ ಕೆಲಸ ಮಾಡಿದ್ರು.
ಹೋಗ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಇರ್ತಾರೆ ನೋಡಿ. ಇಲ್ಲೇದ್ರೆ ಹೋದ್ರ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗಿ.
Lordships kindly.
ಹಾ.
Memo,
ಹೇಳಿ.
sir, forest matter ನಲ್ಲಿ dwelling house disposed of.
ಇವತ್ತಿದೆಯಾ?
ಇಲ್ಲಿ ಮೆಮೋ ಮೂವ್ ಮಾಡ್ತಾರೆ. When lordships are sitting single, whenever you're lord.
ಗವರ್ಮೆಂಟ್ ಏನೋ ಪಾಲಿಸಿ ಸ್ವಲ್ಪ ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡಿ ಏನೇನೋ
Yes. Yes, in the wake of that, my lord, it may be disposed
dispose
of.
of false.
Please,
False.
great.
Sorry, now when I sit single, I'll post it. Ah,
For
Next.
orders. List number 1.
Ah.
Azhar Mir.
Applying for the petition, my lords.
ah,
Lord, in this case, my lord, the state has filed review, my lord.
review file ಮಾಡಿರಾ?
Review I have filed.
Okay. We will consider.
Likely to, yes.
Just look into,
Solely, my lords.
because he has no power at all anta. He cannot
But
decide that.
it's only the mayor as. per
Mayor,
Rule
we can, but there is
77.
no mayor.
There was mayor at that point.
Correct. He did not do. Because he did not do it.
Therefore, my lord, therefore, our submission is that he should also be prosecuted under 432, my lord.
No, no, we'll look into that.
That
Wait.
extent is what.
Okay. Review, ಅದ್ರ ಜೊತೆ ಬಂದ್ಬಿಡ್ಲಿ, ರಿವ್ಯೂ ಪೋಸ್ಟ್ ಮಾಡಿ.
Maybe, yes,
Yes, post learned AGA, AAG, Mr. Kiran Rohn submits that. The state has moved a review petition. And therefore, the same needs to be posted along with this matter.
Review number.
Right. First off, the said review petition is so and so, so and so. Okay. Athwa review petition number so and so may be posted on. All right. Next.
See number 2, for further hearing, Swaroop Srinivas.
Yes.
Pertaining to the sugar factories.
ಹಾ ಹೇಳಿ, ಮತ್ ನಾ ಮರೆಯೋಕ್ಕಿಂತ ಮೊದ್ಲೇ ಹೇಳ್ಬೇಕು ನೀವು, ನನಗೂ ಮರ್ತು ಹೋಗ್ತಾ ಇದೆ. The retention power is depleting.
In fact, dictation was already given insofar as our arguments are concerned. Senior
Ah.
counsel is unavailable today, but we have.
Ah.
Even senior is not,
ಹಾ.
will not be able to appear today. Mr. Wood.
ಕಿರಣ್ ಏನಿದೆ ಇದರಲ್ಲಿ ಏನು?
but in this case, my lord, we have
Ah.
filed a report. Lordship had wanted a report,
ಯಾಕೆ ಬೇಕು ಅಂತ ಹೇಳಿ.
but even then, my lord, the yield if taken into consideration, what we have said is about 92 villages. Put together 7,52,000 metric ton is what is
So
available.
they can coexist.
They may not be because
May
the
not be.
crushing capacity of one is about 5,000 TCD tons crushing per day. The other one is 2,500 per day.
One
And,
is
the
5,000, another is 2,500.
Sharda
Together
Sugar-
ಎಷ್ಟಾಗ್ತದೆ?
Sharda Sugars will need about 3,50,000. Nadalli will need about 7 lakhs. So put together 10 lakhs is what should be the output.
But actually available is,
7,52,000. Have placed
that's the
that-
minimum ಅನ್ನೋದು.
the
Minimum
depends-
crushing limit ಇದೆಯಾ?
Minimum, the capacity is 2,500 TCD, so they will use it crushing per day, my lord. That's how they calculate what I'm instructed. But again, it can be
ಅದು seasonal ಅಲ್ವಾ?
sugarcane seasonal.
Seasonal.
Yes.
ಮತ್ತೆ ಯಾವ period ನಿಂದ ಯಾವ period ತನಕ crushing?
I-
You are assuming that for a whole year it will be crushed ಅಂತ. The crushing is not for whole year.
Yes, for the
Under-
license year itself,
ಲೈಸೆನ್ಸ್ ಇಯರ್ ಅಂದ್ರೆ
it will end by usually by
particular
June.
period. ಆ ಪೀರಿಯಡ್ ನಲ್ಲಿ ಎಷ್ಟಾಗ್ತದೆ ಇಬ್ರದ್ದು ಲೆಕ್ಕ ಮಾಡಿ ಹೇಳ್ಬೇಕು. That is very important.
Correct, we have taken that itself.
That itself.
But we can explore whatever. Ultimately, I provided this.
ಸ್ವಲ್ಪ
data.
calculation ಮಾಡಿ 5,000 into 365 ಮಾಡಿ.
May I just pass on the memo?
ಇಲ್ಲ ಬಹಳ ಜಾಸ್ತಿ ಆಗ್ತದೆ.
18,25,000.
ಅವಾಗ ಅಲ್ಲೇ ಎಕ್ಸೀಡ್ ಆಗಿ ಹೋಗ್ಬಿಡ್ತದೆ. ಅದು ಸೀಸನಲ್ ಯಾವ ಪೀರಿಯಡ್ ಇಂದ ಯಾವ ಪೀರಿಯಡ್ ಕ್ರಶಿಂಗ್ ಪೀರಿಯಡ್ ಯಾವ್ದಿದೆ?
Crushing period, I believe till June, man.
ಅದು ಡೇಟ್ ಇದೆ ನಮ್ಮ ಡಿವಿಷನ್ ಬೆಂಚ್
I can
ಜಡ್ಜ್ಮೆಂಟ್
find
ಇದೆ ಅದ್ರ ಮೇಲೆ.
No, the crushing season itself
ಹಾ,
ends because the.
ಫ್ರಮ್ ವಾಟ್ ಪೀರಿಯಡ್ ಟು ವಾಟ್ ಪೀರಿಯಡ್?
Sugar cane also, my lord.
Sugar
Yield
cane
recovery,
ಬರ್ಕೊಂಡು, ಹ?
recovery, my lord.
Correct.
Depends on the, up to 12 months, one rate of recovery, my lord.
ಕರೆಕ್ಟ್.
Post 12 months will have another rate of recovery. So till June, usually the crushing season takes place.
ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಇದ್ರ ಮೇಲೆ.
From December onwards.
ಯಾವ
till-
ಪೀರಿಯಡ್ ನಿಂದ ಯಾವ ಪೀರಿಯಡ್
I'll find
ಅಂತ
out.
ಹೇಳಿದ್ರೆ
I'll find out.
ಅದು ಕ್ರಶಿಂಗ್ ಪೀರಿಯಡ್. ಬಿಯಾಂಡ್ ದಟ್ ಪೀರಿಯಡ್ ಆದ್ರೆ ಡ್ರೈ ಆಗಿ ಹೋಗ್ಬಿಡ್ತದೆ ಕೇನ್.
They won't-
ಹಂಗೈತೆ. ಹಾ, ದಟ್ ವಿಲ್ ನಾಟ್ yield any juice at all. Therefore, they have fixed the crushing period.
Yes,
ಆ ಕ್ರಶಿಂಗ್ ಪೀರಿಯಡ್ ನಲ್ಲಿ ನಂಬರ್ ಆಫ್ ಡೇಸ್ ಎಷ್ಟು ಬರ್ತದೆ ಅಂತ ನೋಡಿ,
I'll find out.
ಮಲ್ಟಿಪ್ಲೈಡ್ ಬೈ ದ ರಿಕ್ವೈರ್ಮೆಂಟ್.
Yes.
ಆ ರೀತಿ ಮಾಡಿ.
There's a sugar, there's a research institute,
ಹಾ,
which the government itself has
ಹಾ,
set up.
ಅವ್ರಿಗೆ ಕೇಳ್ಬೇಕು.
One in Belgavi, my lord.
Okay.
Nijlingappa Research Institute. One in Mandya, my lord.
Okay.
In fact, all the sugar factories take help of these research institute.
ಮಂಡ್ಯ.
Both.
Okay.
The Nijlingappa as well as where they, in fact, now they have started colleges also. The students are hired by the sugar factories.
Oh.
So they are expert in this.
Okay.
I'll seek information
ಅವ್ರು
from them.
ಕರೆಕ್ಟ್.
In the meanwhile, I'll also assist the.
ಅದು ನೋಡ್ಕೊಂಡ್ಬರ್ಬೇಕು.
I'll take it step.
ನಾ ತುಂಬಾ ದಿವ್ಸ ಬಿಟ್ರೆ
I-
ನಾ
I can
ಮರ್ತು
keep-
ಬಿಡ್ತೇನೆ.
I'll keep the director of that research
Very
institute
good.
present. no?
Correct.
So he'll be in a position to answer any query.
ಅಲ್ಲೇ having heard the matter further again, come on. Learned AAG is requested to keep the director of one of the sugar,
Nijlingappa Research.
ನಿಜಲಿಂಗಪ್ಪ ಎಂತ ಏನು
Research
ಫುಲ್
Institute, yes.
ನಿಜಲಿಂಗಪ್ಪ ರಿಸರ್ಚ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ so and so on the next date of hearing, that is one date fix ಮಾಡ್ಬಿಡ್ತೀವಿ.
ಮಾಡ್ಬಿಡು.
So that it becomes easy.
Yes, ma'am.
Friday evening ಹಾಕ್ಬೋದಾ?
31st. Yes,
Friday evening,
Kindly.
Friday afternoon,
31st.
Friday afternoon.
2:30 or something.
ಅವತ್ತೇ ಇದೆಯಾ? ಬೆಳಗ್ಗೆ ಅದು ಇಟ್ಕೊಂಡ, ಇದು ಮಧ್ಯಾಹ್ನ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು.
ಹೌದು, 31st ರಿಟೈರ್.
Huh?
ಹಾಫ್ ಡೇ ಶಿವಶಂಕರ್ ಗುಡ್ ಸಾಹೇಬ್.
You're right. ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ನಾ ಮರೆಯೋಕ್ಕಿಂತ ಮೊದಲೇ ಮುಗಿಸ್ಬೇಕು.
Yes.
ಅದು ನಿಮ್ದೊಂದು ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ ಅಲ್ಲ, ಅದೊಂದು ಇದೊಂದು. ಅದರ ಮ್ಯಾಟ್ರಸ್ ಏನ್ ಬಹಳ ದೊಡ್ಡದಿಲ್ಲ. 1st of February,
That is on Saturday.
ಈ ಸ್ಯಾಟರ್ಡೆ.
Kindly, 1st of February.
ಅದ್ ಇನ್ನೊಂದು ಹಾಕೊಂಡಿವಲ್ಲ ಅದನ್ನ ಟುಡೇ ಮಧ್ಯಾಹ್ನ ಹಾಕೊಂಡೆ, ಇದನ್ನ ಮಾರ್ನಿಂಗ್ ಹಾಕೊಂಡ್ಬಿಡ್ಬೋದಾ? ಹಾ, ಹಾಕೊಂಡ್ಬಿಡು. 1st of February, ಸಿಂಗಲ್ ಆಕ್ಷನ್.
Great is.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಎಂಟ್ರಿ ಮಾಡಿ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೋಬೇಕಾ? ಹಾ.
Even a fresh calculation.
Yes, it's fish.
ಬೆಳಿಗ್ಗೆ ಸಿಂಗಲ್ ಮಧ್ಯಾಹ್ನ
This is for further hearing.
ಇದು
Yes, sir. Yes, sir.
release from fraud. D ಇಲ್ಲ D
Release,
Release.
released. Already released. ಇನ್ನೊಂದ್ರಲ್ಲಿ
ಅಷ್ಟೇ ಅಷ್ಟೇ ಅದು
released.
from part.
So directional release ಅಂತ ಇಲ್ಲ. Released.
ಇವ್ರು ರಿಲೀಸ್ ಮಾಡೋದು.
Interim order granted earlier.
ಈ ಮಾತುಗಳು ಇವೆಲ್ಲ ಯಾವಾಗ ಕೊಡ್ತಾರೆ ಕೇಳ್ಬಿಡ್ತಾನೆ ಕೊಡೋದು. ಈಗ
Interim order ಬಂದೆ.
ಇಂಚಲ್ಗೆ ಮೇಲೆ ವೈಟ್ ಹಾಕೋದು ಏನು ತೊಂದರೆ ಇಲ್ಲ, ಕೆಳಗೆ ಆರಾಮಾಗಿ ಬರೀ.
ಅದೊಂದು ಡಾಟ್ ಶೀಟ್ ಕೊಟ್ಬಿಡಿ ಮಾರ್ಕ್ಸ್ ಇಲ್ಲ ಫೈಲ್.
ಮೇಡಮ್ ಹಿಂಗೆ ಮಿಸ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್ ಅಲ್ಲಿ
ಬೇಡ,
ಇವ್ರುಗಳು ಮಾಡೋ ಇದಕ್ಕೆ ಅಷ್ಟು
ನಾಳೆ-
ಯಾರು ಅಷ್ಟು ಇದಿಲ್ಲ ಮೇಡಮ್, ಸ್ಮಾರ್ಟ್ ಇಲ್ಲ. ನೋಡ್ತೀನಿ
ನಾಳೆ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಸರ್.
ಹಾ?
ನಾಳೆ ಇಲ್ಲ
Okay.
ಸೊ ಫ್ರೈಡೆ ಬೆಳಗ್ಗೆ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಮಾರ್ನಿಂಗ್ ಮಧ್ಯಾಹ್ನ
ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಇಲ್ಲ ಬಿಡಿ, 31st ಬರೀ ಹಾಫ್ ಡೇ ಅಷ್ಟೇ ಅವತ್ತು.
ಕರೆಕ್ಟ್
Next Saturday.
ಸ್ಯಾಟರ್ಡೇ ಮಾರ್ನಿಂಗ್ ಸಿಂಗಲ್ ಮಧ್ಯಾಹ್ನ ಶುಗರ್ ಫ್ಯಾಕ್ಟ್ರಿ.
ಶುಗರ್ ಇಲ್ಲ, ಮಾರ್ನಿಂಗ್ ಶುಗರ್ ಫ್ಯಾಕ್ಟ್ರಿ,
ಮಾರ್ನಿಂಗ್ ಶುಗರ್ ಫ್ಯಾಕ್ಟ್ರಿ
ಮಧ್ಯಾಹ್ನ ಪೂರ್ಣತೆ ಸಾಹೇಬರು ಪೆನ್ಷನ್.
ನೋಟ್ ಮಾಡ್ಕೊಂಡು
ಮೇಡಮ್ ಹೇಳಿ ಹೇಳಿ.
Sir, I'll cry now. I'll cry now, sir.
Speak to that photo.
Not sitting tomorrow.
You can leave. If you are a sitting singer, I would have got it this. Everything is ready. Now you have to speak that, what is the number? 5?
573. 573. 573 only, sir.
0.75. Now they. What you do is, you go to board branch. Meet Mr. Mayor. Tell him that I have moved a more. Tell him to post it on the.
Will you listen to me?
Just tell him that You have moved them. Lots of here.
Hmm.
They will also appeal. Now, see the bench is going, otherwise I would have met that court of.
Hmm.
Till one day, tomorrow is there, no?
To Justice Devdas's court of.
That time when it doesn't read, take care.
Yeah. That's Suhas, I tell him.
Very
How
difficult.
many times I have to tell him, sir, to come and give you?
Hmm.
I will be in trial court, that's why I'm not able to come. But he should at least come, no? I'll. And the board branch and all, they will not listen to me, sir.
So ಇದು ನೋಡಿ ಇದೊಂದು ಹೌದು ಇದು ಮೇಡಮ್ ಬರೀಬೇಕು ಯಾವ್ದ್ರಲ್ಲಿ ಬರ್ದ್ರು ಮೇಡಮ್ ಇದು ಮೇಡಮ್ ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಫುಲ್ ತೊಗೊಂಡೋಗ್ಬಿಡಿ ಫೈಲ್ ಬಟ್ಬಿಟ್ಟು ತೊಗೊಂಡ್ಬನ್ನಿ ಇದು ತೊಗೊಂಡೋಗಿ ಮೂರು ಸಿಗ್ನೇಚರ್ ನೋಡಿ It's not picking. Every day I am following it up. What? There is lot of raises now. I'll speak to the court officer and we'll try to get it listed on Monday or Tuesday.
Then, 6th of Jan, we're trying vacation also.
It came twice, huh? Twice or once before
Once.
RTJ. That day I came to the court in fact that I thought that it will reach on that day.
Correct, we thought, but then he said division later, so it didn't reach.
Please, we should have told them. I would have spoken to that court officer and I would have got a date. It's a difficulty every time. Even I can't move from here.
True, true,
Sitting
sir.
in with that, yeah. I have to send my peons, pay them, everything, pays for car. From here only I do everything. Over the phone. Yeah, okay, I will try to get it on Monday or Tuesday.
Let me know.
ನಮ್ಮ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಡೇಟ್ ಕೊಟ್ಬಿಡ್ತೀರಾ ಅದೇ ಪೋಸ್ಟ್ ಮತ್ತೆ RP ಅಂತ ಬರ್ದ್ರ ಅದು ಇದು 1ನೇ ತಾರೀಕು ಕೊಟ್ಟು ಡೇಟ್ ಓಕೆ 1/2/2025 yes ma'am.
64 ಇದಾರೆ इसमें रद्दल हो
ये सही इसका को नहीं सर
कौन
63 का
पुराना था सेकंड सेट में वो ये भी मत मेमो सभी इसमें लिख लो मत और फिर
और डिस्पोजल बुक ಕೂಡ दे दाल नहीं
किसे
दादा वो इसमें घुस गया
वैसा वो भी फाइल वैसा गया सब तो नेक्स्ट डे कौन सा के बड़ा मैटर था क्या
नहीं ना
9th को फाइल 9th 10th को
ಹೇಳಿ ಸರ್
ಮಹೇಶ್ ಅದು ಫೈಲ್ ಹೋಯ್ತಾ ಮಹೇಶ್ ಅದು
ಯಾವ್ದು ಸರ್ ಅದೇ ರೆಡ್ ಪಿಟಿಷನ್ ಅಂತಲ್ಲ
ಹಾ
ಹೇಳಿದೀನಿ ಅವನಿಗೆ ಅವ್ನು ಇನ್ನೂ ಫೈಲ್ ಹುಡುಕ್ತಾ ಇದೀನಿ ಇನ್ನೂ ಲಿಸ್ಟಿಂಗ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಸರ್ ನಾನು ಹೇಳಿದೆ ಅವ್ರಿಗೆ ಅವ್ರು ಲಿಸ್ಟಿಂಗ್ ಅವ್ರ ಮುಂದೆ ಆಗ್ಬೇಕಂತಪ್ಪ ಮೆಮೋ ಮಾಡಿದ್ದಾರೆ
ಹಾ
ಅರ್ಜೆಂಟ್ ಅಂದೆ ಸರ್ ಆಯ್ತು ಹಾಕೊಡ್ತೀನಿ ಫೈಲ್ ಹುಡುಕ್ಬೇಕು ಅಂತ ಹೇಳ್ದ
ಬರೀ ಡೌನ್ ಮಾಡೋದ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದ ನಮ್ಮ ಪಾಷ ಅವನು
ನಾನು ಹೇಳ್ತಾನೆ ಇದೀನಿ ಅವ್ನಿಗೆ
ಹಾ
ಈಗ ನೋಡಿ ಮತ್ತೆ ಹೇಳ್ತೀನಿ ಹಂಗೆ ಹೇಳ್ತಾನ ಅವನು
ಹಾ
ಒಂದ್ ನಿಮಿಷ ಹಾಗೆ ರೀ
ಫೈವ್ 73 का फोटो ಮೂರು नहीं उठाता वो
तूने तो स्टार्ट किया
वो
सही
वो
सही
तो
उन्नीस सही
ಇನ್ನೊಂದು ಈಗ ಫೈಲ್ ಇದೆಯಾ ಅದು ಇಲ್ವಾ ಸರ್ ಫೈಲ್ ಕಳ್ಸಿದಾರ ಸರ್ ಅದು
ಕಳ್ಸಿದಾರಂತಾರೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ ನಾನು ಸುರೇಶ ಕಳ್ಸಿದಾರ ನೋಡಿ
ಒಂದ್ ನಿಮಿಷ ಬುಕ್ಕಲ್ಲಿ ನೋಡು ನಾನು ಫೋನ್ ಮಾಡ್ತೀನಿ ತಡಿ.
ಮಾಡಿ ನೋಡು ಅಭಿ ಫೈಲ್ ಗಂಡು ಮರ ಸರ್ ನದೀಮ್ ಸುರೇಶ್ ಕೊಡಿ ಸುರೇಶ್ ಇದ್ದಾರಾ ಏನ್ರಿ ಸಮಾಚಾರ ಅಲ್ಲ ರೀ ಇಲ್ಲೂ ಆಟ ಆಡಿಸ್ತಾರ ಅಲ್ಲೂ ಆಟ ಆಡಿಸ್ತಾರ ಆ WP 573/25 ಎಲ್ಲಿದೆ ಹಾ GM ಪೊಲೀಸ್ ಅದೇ ಹೋಟೆಲ್ ಮೆಮೋ ಐತಲ್ಲ 25 ನಾನು ಮೊನ್ನೆನೆ ಇವ್ರು ಕೇಳ್ದೆ ಮೀರಾಬಾಯಿಗೆ ಹೇಳ್ದೆ ಮೇಡಮ್ ಬರ್ಕೊಳ್ಳಿ 2 ನಂಬರ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಒಂದು ಪಾರ್ಟೆಡ್ ಮೆಟ್ರ್ ಹೋಯ್ತು ಇದು 573/25 GM ಪೊಲೀಸ್ ಒಂದ್ಸತಿ ಪಾಸ್ ಆದ್ಮೇಲಿಂದ ಪಾಸ್ ಆಗಿಲ್ವಾ ನಿಮ್ಮ ಸ್ಕೂಟ್ನಲ್ಲಿ ಇದೆಯಾ ಹಲೋ ನಾಳೆ ಸಿಂಗಲ್ ಇಲ್ಲ ರೀ ಸ್ಕೂಟಿ ಹಲೋ ಮೇಡಮ್ ನಮಸ್ಕಾರ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್ WP 573/25 ಈಗ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಇಷ್ಟೊತ್ತು ಅಲ್ಲಿದೆ ಅನ್ಕೊಂಡು ಫೈಲ್ನ ಫೋಟೋ ಮೆಮೋ ಆಯ್ತು 25 ಅದು ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಹಲೋ ಸೈನ್ ಹೋಗ್ಯಾ ಸ್ವಲ್ಪ ಓ ಬಡ ಫೈಲ್ ಹಾ ಮೆಮೋ ಇದೆ ಮೇಡಮ್ ಮೆಮೋ ಬಂದಿಲ್ವಾ ಅಯ್ಯೋ ಅದು ಎಲ್ಲಿ ಕೊಡ್ರ ಹಾ ಮತ್ತೆ ಕಳ್ಸಿಲ್ವಲ್ಲ ನಮಸ್ಕಾರ ಯಾರು ಮಾತಾಡೋದು ಅಂದ್ರೆ ರಾಘವೇಂದ್ರ ರೀ ನಮಸ್ಕಾರ ಇದೊಂದು 573 ಮೂವ್ ಮಾಡಿದ್ರು ನಾನು 10:30 or 2:30 ಅಂತ ಬರ್ದು ಕಳ್ಸಿದ್ದೆ ನಾಳೆಗೆ ಅಂತ GM ಪೊಲೀಸ್ ನಮ್ಮ ಸಾಹೇಬ್ರು ಸಿಂಗಲ್ ಕೂತ್ಕೊಂಡ್ರೆ 10:30 ಯಾರು GM ಪೊಲೀಸ್ ಬಂದಿಲ್ವಾ ಅವರು ಸುರೇಶ್ ಮೆಮೋ ಕೊಟ್ರಂತಲ್ಲ ನಿಮ್ಗೆ ಆ ಕಡೆಯಿಂದ ಸ್ಫೂಟ್ನಿಕ್ ಕಳಿಸಿದೆ ನೋಡು ಅಂದ್ರು ಹೌದಾ GM ಪೊಲೀಸ್ ಅಂತ ಯಾರು ಒಂದು ನಿಮಿಷ ಯಾರು ಇವಾಗ 573 ಇದೆಯಾ ಇಲ್ವಾ ಫೈಲು ಇತ್ತು ಅಂದ್ರೆ ಕಳ್ಸ್ಕೊಟ್ಬಿಡಿ ಅಲ್ಲಿ ಹೇಳ್ತೀನಿ ಬೋರ್ಡ್ ಕಳಿಸ್ಬಿಡಿ ಬೆಸ್ಟ್ ಅದು ಓಕೆ ಈಗ
Without memo cases होता है हाँ नहीं डालता नहीं डालता अब वो मेमो किधर गया मुझे क्या मालूम तुम्हें ना दिए होता था हाँ तुम्हें किधर किधर दिए मेमो कौन सा RFA 573 का फोटो मेमो वो GM का पेंडिंग टाइप वो नहीं लिख रही पेंडिंग की इसको ये उन्होंने लिखा बाजू में जो सिंगल जज का हां ये गिवन मैं ये सेक्टर का ये मेरा सिंगल तुम्हें खाली करके अच्छा ये किधर फाइल मिल जाता मेमो नहीं मिलता मेमो मिल जाता फाइल नहीं मिलता था Number, three memos, sir. One memo GM ಕೊಟ್ಟಿದ್ದೀರಾ ಇನ್ನೊಂದು memo ಎಲ್ಲ BDI ಕೊಟ್ಟಿದ್ದೀರಾ LB ಇನ್ನೊಂದು ಯಾರು ಕೇಸ್ ಇರ್ತಾರೆ ಒಂದು ಸಿಸ್ಟಮ್ ಬಿಡೋದು ಅವನ ಬನ್ನಿ ಮತ್ತೆ ಫೈಲ್ ಸ್ಕೂಟಿ ತಗೊಂಡಿ ನಮ್ಮ ಅವ್ನಿಗೆ ಯಾವ ತಗೊಂಡ ಅವ್ನಿಗೆ ಸ್ಕೂಟಿಗೆ ಹೋಗ್ಬಿಟ್ಟು ಯಾರು ಕೊಡ್ತೀನಿ ಮತ್ತೆ ಯಾರು ಕೊಡ್ತೀರಿ ನೀವು ಇವಕ್ಕೆ ಅದೇ ಸ್ಪೆಕ್ಸ್ ಹಾಕೊಂಡು ಕೂತ್ಕೊಂಡಿದ್ದಾನ ಬಿಸಿ ಬಿಟ್ಕೊಂಡು ಅವ್ನು ತಾನೇ ಸಿಸ್ಟಮ್ ಮುಂದ್ಗಡೆ ಅಯ್ಯೋ ಟಿವಿ ಸ್ಕೂಟಿ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು ಓಕೆ ಸರ್ ಸಿಂಗಲ್ ಅಂತ ಸರ್ ಹೋಗೋ ಸ್ಕ್ಯಾಮ್ ಆಗಿದ್ದು ಈ ಟಿವಿ ಹೋಗೋ ಸರ್ ಯಾ ಟಿವಿ ಸಿಂಗಲ್ ಪ್ಲಾನ್ मैं उतना मैं ऊपर सिंगल करके जाता हूँ ऊपर इधर ही अगर केस दीजिए सिंगल करके डाल होता है ಅದೊಂದು ಫೈಲು ಮೆಮೋ ಸರ್ ಆಯ್ತು ಅದೊಂದು ಮೆಮೋ ಇದ್ನಲ್ಲ 573 ಅವ್ನು ತಗೊಂಡೋಗಿ ಅಲ್ಲಿ ರೂಮ್ ಕೊಟ್ಟಿದ್ದಾನೆ ಅಲ್ಲ ರಿಟರ್ನ್ ಡಿಪಿ ಕೂತ್ಕೊಂತಾರೆ ಸ್ಕೂಟಿ ಕಿರಣ್ ಹಾಂ 573 ಸ್ಕೂಟಿ ಅಲ್ಲಿದೆ ನೋಡಿ ಹಾಂ ಓಕೆ ಓಕೆ हाँ टोटल be single, no be. Never be single,
इसको क्या भी मिस्टेक नहीं सर सीपी नहीं
फोटो
हमें उन्हें पढ़ता नहीं उन्हें
इसके वास्ते वो कंफ्यूजन ना सही होता करके वैसे ठीक है सिंगल करके डाल होता
मुझे देश की ना
ना ए ना दिया मैं उसे दे रखने के लिए फोटो मंगा बुक में वो पैसे निकले नहीं जमा डलवाए तो इसके
यार मैं दस बेटिंग है मैं वो जब करूँ मुझे क्या सिंगल को डालता है यार सब करने में
तो नहीं होता
रिस्क की वजह से उनको बुमड़ी मानना सर सबमिशन करना सर
हाँ
पूरे रूट्स
अभी चाहिए थे अभी इधर आगे करके अभी और रेडी करते अभी जा रहा है पास से फोटो बनाए हुआ है बाकी एक बार देने लिए एक बार बाद में रुपये आगे लेके आया देखो सुबह है ना छुट्टी था क्या क्या लिखे दे नहीं तो लेगा
नहीं सर मैं तो प्रसन्न हूं आपकी सेना होना वो बिल ले सो उसका क्या भी नहीं है
ऑटोग्राफ है ना इसलिए
वो छोटा सा क्या ना तो अच्छे ही सो